Welcome to Looking at Legal Stuff. Today we have 16 hearings, including 4 new updates, in a case with a couple where the wife has filed a motion for contempt against her soon-to-be ex-husband, who is court-ordered to pay temporary spousal support during the divorce process. But he's been refusing to make proper payments, claiming he can't afford it, even though he hasn't motioned the court for reconsideration or provided any of his financial information to help prove this. The judge becomes increasingly dubious of his claims and finally threatens him with jail if he doesn't comply. Will he start making payments on time, or will he be ordered to jail? Let's find out.
Let's take the Brenda Mortensen and Stephen Mortensen matter. That's 223388808 is the cause number. Ms. Bliss represents Brenda Mortensen. Ms. Bliss is here. And is Brenda Mortensen, are you on the line today? Looks like she's not. And then I see Mr. Stephen Mortensen is on the line. He's been waiting patiently for us. Can you hear me okay, Mr. Mortensen?
Yes, Your Honor, I can hear you.
All right, very good. Thank you. So we're here today on a motion for contempt. It looks like service was proper in that Mr. Mortensen was served with all relevant documents on December 17th, and we're here today. And it's an issue apparently related to maintenance and a credit card. So let me just double check. So I read all the documents that Ms. Bliss filed, and I wanted to make sure that Mr. Mortensen, if you had filed something, I haven't seen it. So I just want to check status with you. If you filed something, I haven't seen it, and I just want to make sure we're on the same page.
No, I have not.
Okay. Do you have an initial position related to the motion brought by Ms. Bliss? Are you agreeing or denying it?
I'm denying it. I'm not intentionally not paying these things. I work 40 hours a week full time. My net income is $4,000 per month, and I have bills, that I have to take care of that exceed the $4,000 a month that I make. I have a truck payment, insurance, phone, and my medications. On top of that, I have almost $400 a month taken out of my check for my health insurance, which does help with my diabetes medication, but I still end up paying about $90 a month for my prescriptions, which includes 2 different types of insulins and like that. So I'm not intentionally not paying these things. I have made some payments of what I can make at the time. I just got the information from Red Canoe on the credit card. So I plan on starting to make payments on that. As far as the maintenance goes, Brenda walked away with over $160,000 from the sale of the house, plus all the furnishings. When I left with my clothes, my fishing gear, and that was it. I didn't buy the truck until after I was already out of the house. And I don't feel that there should be any type of maintenance, considering the fact that she walked away with everything. The total proceeds from the sale of the house and all the furnishings. That's what I've got.
Okay. All right. Thank you, Mr. Mortensen. I appreciate your input. Ms. Bliss.
Thank you, Your Honor. For the record, I do represent Brenda Mortensen in this matter. I would just note for the record that Mr. Mortensen has never filed any sort of financial declaration, has never provided the court pay stubs or anything of the like, which is why Judge Hahn on September 27, 2022, adopted my client's request, entered an order requiring him to pay spousal support in the amount of $1,500 per month to pay the Red Canoe credit card and the IRS debt, And as outlined in my client's motion before the court today, he's failed to do any of those. She's received 2 payments since entry of that order, a $400 payment and a $200 payment. And that is the extent of the payments being made to my client. Again, this order was backdated to August when the petition was filed, and he has made $600 as opposed to the $1,500 per month. By my calculation, he's behind $6,900 as of February 15th. Obviously, now we're into January, and it's likely that another month of $1,500 is going to be added, being as he's made no payments. Further, my client provides for the court that under that order, she agreed to take the lion's share of the debt. She's making 2 car payments, paying 2 medical bills, and is paying a loan on her 401k that the parties inquired during the relationship. Again, this is a 23 and a half year marriage where Mr. Mortensen was the primary provider. My client was largely unemployed throughout the course of the marriage. She is now working part-time at Walmart and doesn't have sufficient funds to provide for herself, which is why the court previously entered the order it did, requiring him to contribute to the household. My client provides for the court that she is making the payments to the debts that he is required to pay simply to save her credit. She has paid over $900, I believe it was $915.12 towards that Red Canoe bill. She's asking for reimbursement for those, being as those are the court order that Mr. Mortensen pay those debts. So for purposes of today's motion, we're asking the court to find that Mr. Mortensen has willfully and intentionally violated the court order entered on September 27, 2022, because he has failed to provide payments to the court, or payments to my client, excuse me, and has failed to provide anything to the court to substantiate any allegation that he simply cannot afford it. That is not a defense to violating the court order, and I ask the court not to consider that, being as nothing has been provided to the court throughout the entirety of this case, frankly. So for purposes of a judgment, we are asking the court to enter a judgment regarding reimbursement of the debt payments that my client has made for a total of $915.12. We're asking for the spousal arrears from August 1st to December 15th, obviously giving credit for the $600 in payments my client has received. That payment, or that judgment, excuse me, should be $6,900. And we are asking for a contribution of attorney's fees in the amount of $750. Again, my client is of modest means, does not have the funds to, frankly, bring motions before the court to require Mr. Mortensen to comply with the court orders. So we are asking for a contribution of attorney's fees in the amount of $750.
Thank you, Ms. Bliss. Ms. Bliss, does that figure of $6,900, does that take into account the 2 payments that I see that Mr. Mortensen did make of $600?
Correct, Your Honor.
Okay. All right, thank you. All right, Ms. Mortensen, I'll give you an opportunity to respond.
Well, number one, like I said, she left the house with over $160,000. You know, and then she's asking for spousal support. I'm working full time, and there's no way that I can spend almost half of my disposable income on a spousal support payment that is ridiculous to begin with, because she is working full time. Unless she has changed something in her employment herself, she's working full time at Walmart. That's how she was hired in there, and that's what she's been on ever since she started, is full time. The 2 car payments, the 1 car, it was a brand new Honda, and that was her car. That was how she got back and forth to work. The other car is my son's car. He has been making the payments on that because he works as well, and he is making the payments on that. The loan is in my name, but he has continued to make the payments on that. As far as you know, willfully not paying it, if I can't make the $1,500 a month payment for the spouse support, there's no way that I'm going to be able to come up with a lump sum of $6,000. I mean, I have stuff that I have to pay for also in order to live and to try to keep myself healthy. And there's just no way.
Okay. All right, thank you, Mr. Mortensen. So what I'm looking at the September 27th, 2022 temporary family law order that was signed by Judge Hahn. And in that order, she indicates that there's an obligation to pay $1,500 per month in the form of spousal maintenance. And she also looks like she wrote in by hand, she said that amount that's paid on a monthly basis can be taken into consideration at the time of trial regarding the division of assets. So it kind of gives a nod to what Mr. Mortensen is saying. He said, hey, look, she got $160,000 from the sale of the house. And that very well may be a consideration when the case goes to trial, as well as any payments made to spousal maintenance. And it may even things out to a degree. However, the point we're at right now, we're not re-arguing the September 27th order. The September 27th order is what it is. And there's been a motion and that's seems to be substantiated in that Mr. Mortensen has indicated that he's made two payments, totaling about $600. It doesn't sound like he's disputing that he's made those payments, which is far short of the amount that was ordered by the court. I'm not one to tell people how to live their lives. I recognize that court orders impose some serious obligations on parties. We have to take into consideration that a household had been in existence for 23 years, and there's certain guidelines that the law requires and the law asks us to follow in setting maintenance. And so, for all I know, all I know is that there's an order in place, and it requires a payment of $1,500 per month. I don't have any financial declarations or pay stubs. I take Mr. Mortensen at his word. He's probably making net around $4,000 a month, and money's tight, and he doesn't have a bunch of extra floating around nor growing on trees. Nonetheless, I don't have anything to indicate that his net income is anything less than what he stated. And is $1,500 a huge chunk of a net income? It is. It's a huge chunk. And yet at the same time, there's a court order that requires that to be in place. Now, if I had some financial documents that would lead the court to believe something differently, then there might be a change in that order of spousal maintenance. But at this point, we don't have any of that information. So the information that I have is basically what I've gleaned here today from Mr. Mortensen. So there's income. I recognize that there's outflows, and I will make a finding that there's been a willful and intentional failure to pay the maintenance from the period of August 1st through December 15th, with an offset for the payments made of $6,900, and I'll enter a judgment therein for that amount. And it sounds like Mr. Mortensen is making some arrangements to take over the credit card payment. He's ordered to do that. Looks like the Ms. Mortensen has made payments on that to avoid any negative credit reporting history. So she's paid September, October, and November with substantiation of bank records of $915.12. That'll also be reduced to a judgment in behalf of Ms. Mortensen. There's a request for attorney fees. I'll grant that for $750. So that'll be the court's judgment. Ms. Bliss, do you have any questions, or Ms. Mortensen, do you have any questions about the court's ruling?
Your Honor, I did provide a order for the court at the time that I filed my motion. I don't know if you have that before you, if you wanted to enter that judgment and that order today, or if you needed me to represent that to you.
I was sent a scanned copy of those orders yesterday. Let me just make sure. And I was told that the hard copy orders would be in my box today. I haven't checked that. I'm assuming that they're there since they scanned them to me. So I don't think there needs to be any additional submission on your part.
Very good. I don't have anything further, Judge. Thank you.
Mr. Mortensen, did you have any questions about the court's ruling?
Not about the ruling, but how can I go about getting you the financial information that has been lacking as far as the decisions that have been made on this, and when can we revisit this to come to some kind of a reasonable, for me, agreement on this?
Yeah, good question. As far as
I understand
the information with the court, you file everything with the court clerk's office, and then send a copy to opposing counsel. So if you want to go to Cowlitz Superior Court.us, there'll be a link there, or even if you did a Google search, Cowlitz County Clerk's Office, you can get a mailing address and all the different forms. The forms, if you go to cowlitzsuperiorcourt.us, there's a link there for court forms, which are very helpful in submitting documents. You can also check with Cowlitz Wahkiakum Legal Aid. They are very helpful in providing assistance if you qualify. You can also go to Washington Courts. They also have a forms section. So those are your options. The clerk's office, cowlitzsuperiorcourt.us, the forms section, and then Washington Courts, the forms section, and also potentially the Cowlitz Wahkiakum Legal Aid. If you qualify, they can provide some assistance also.
Okay.
Okay, great. So the order that was submitted by Ms. Bliss, I'll sign off on that and file it with the court. All right, so that concludes that matter for today. Thanks. And
next matter, if we could take up, is the Mortensen and Mortensen matter. And this is cause 22-3-38808. Ms. Bliss is representing Ms. Mortensen, and Stephen Mortensen, are you on the line today? Let's see, Stephen Mortensen, if you're on the line, make sure you're unmuted and state your name. Just looking through the Zoom gallery, not seeing anybody with a name that is anywhere similar. So it looks like with Mr. Mortensen, we had the contempt order entered on January 10th, and then there was a provision indicating that he's to be placed on the third Tuesday of each month for a pay or appear to ensure compliance with the child support order. And there was also a docket notice to that effect, which was distributed. Ms. Bliss, have you had any contact with Mr. Mortensen?
I have not, Your Honor. My client did indicate that she has received 2 payments since that last hearing, but those were in the amounts of $200. Which is far less than what the current order is. I did provide another docket notice just to ensure he received notice that this was going to be heard today, but I've not heard directly from him.
Okay. What's the amount what's the full amount that's to be paid?
Let me look, I believe it was $1,800 per month is what you should be paying in spousal support.
Oh, and it's at, you indicated $200 a month that he's been paying.
Right.
Recently.
Yeah, oh, 1,500, excuse me. So pursuant to the September 27, 2022 order, it was $1,500 per month that he was supposed to be paying. And my client indicated that he has paid $200 in January, which was around the time of our just after our last hearing. So our last hearing was on the 10th, I believe. So on the 13th, he paid $200, and then on the 15th of February, he paid $200.
Okay. So looking at that provision, paragraph 13 in the contempt order, it says respondent shall be placed on a monthly pay or appear docket to ensure compliance with his ordered payments. The hearing shall take place the third Tuesday of each month. So the indication is there he's placed on a docket. There's maybe, I don't know if the language is a little less than compulsory or mandatory. It says the hearing shall take place and he shall be placed on a docket. So without his presence here today, I'm not sure if what your next steps would be or requests would be, Ms. Bliss.
I mean, ultimately, I would be requesting attorney's fees for having to appear today to ensure his compliance with the order, which he's repeatedly failed to comply with. If I need to bring another motion for contempt, to bring another show cause order, my client's ready and able to do so. She's just frustrated that we've repeatedly had to come to court for enforcement of the order that he should be paying.
I'm wondering if there's, rather than just a simple docket notice, if there should be some type of specific order that says, you know, this next Thursday or the next third Tuesday of each month, you shall appear. Because that's the intent of that contempt order. The contempt order is that he's there, he's made responsible and accountable, and he can tell us, yeah, I've been paying, or no, I haven't, or these are the circumstances. And so without a specific order, I would be inclined to kind of flesh that out, that contempt hearing order, to maybe add greater specificity or add a separate order that says, okay, on this third Tuesday of each month until otherwise excused, you have to appear in court. So if
Okay.
that's something that you're willing to prepare as far as an order, then that I could sign that, then service could be given to him.
Okay, I can prepare that order and send it over for your honor ex parte.
Okay. All right. Great. Thank you. Appreciate that.
Thank you, Judge.
Next, I see Mr. Zandy's camera's on, representing.
And
Great. And then we should have Mr. Stephen Mortensen. Mr. Stephen Mortensen, are you on the line today?
I'm here.
Okay. All right. Very good. Welcome. Looks like there was a contempt order that was filed on January 10th of this year. Indicated there was a past spousal support owed of $6,900 plus a civil penalty and attorney fee of $750 and a credit card reimbursement of $915. And that we set this on to what's called a pay or appear docket every third Tuesday of the month. And that there was a show cause order served on Mr. Mortensen related to that review hearing. So I'll hear from Mr. Zandy first and then hear from Mr. Mortensen second, please.
and good morning, Your Honor. Can you hear me? I was having some microphone difficulties a few moments ago.
Yeah, you're coming through. That.
In any event, we are set for review. This is my understanding that Mr. Mortensen's to appear every third Tuesday of the month and review the status of his payments pursuant to various findings and contempts that have been made. Most recent information provided by our client indicates that Mr. Mortensen did pay $200 on Friday the 14th. Outside of that, we've gotten very little. Best of my knowledge, he's paid nothing towards the credit card as court ordered. He's paid nothing towards the IRS as court ordered. And again, this is a case where he's responsible for $1,500 per month in spousal support. It appears that he has the means and the resources to pay what the court has obligated of him. But to date, he's continues to have issues paying so in a complete and timely manner. No, this is now several times that Ms. Bliss has had to appear before the court, and we largely have ongoing non-compliance with this. Not sure where this puts us. Again, I do understand that it's been every third Tuesday of the month that he's been essentially required to appear. But at this point, my client is going backwards in what she would be getting for support and legal fees to be here once a month. So that's kind of the latest from our end. It does appear that he's present. I don't know what the justification is for only paying the $200, but again, that is pales in comparison to what is required of him under the order.
Thank you, Mr. Zandy. Mr. Mortensen, what's your perspective?
As far as the credit card payment, I've been told by the bank, which is the credit union, that I can't do anything on the card. I can make payments, but Ms. Mortensen is still using the card little bits and then putting back in. So I'm trying to get her name removed off the card or something so that I can have full control of the card and make the payments as needed. Are you still there?
I am.
Okay. Lost video for a minute. And as far as the rest of it, I've got a truck payment and phone payment, rent payment, and like that. And I'm struggling right now to keep up with everything that I've got. Mrs. Mortensen did receive all of the funding from selling the house, which was $168,000, I believe. And she has already spent that, as far as I know. And that was on a verbal agreement when we separated that she would get that. And it's just, I've got to live too, and I'm paying what I can pay. It's just a struggle at this point.
So you paid $200 on April 14th. Is that accurate?
Yes, and I've paid at least $200 a month every month since like January.
Okay, and is that $200? Is that going towards the credit card, or is that going towards the attorney fees, past spousal support? How are you making that payment?
It's going into a bank account in her name,
Okay.
with Chase Bank, and I'm just depositing $200.
Okay. And how much do you pay for your truck each month?
I pay $341,
How much do you pay for your phone?
165, I believe.
And rent?
Rent is 800.
And how much do you pay each month in spousal support?
I just $200 a month is what I've been paying.
What's the court order?
15, I believe.
So the $200 kind of what I'm thinking is, back on January 10th, there's a court order that ordered you to pay roughly $8,000. And then there's on top of that, or before that, is the requirement to pay spousal support. So there's a court ordered you to pay something, but you're not paying that. There's two things the court's ordered you to pay. One is the spousal support. Two is the back child support, or back spousal maintenance, pardon me, that you're not paying. You're not even touching that. So what's your plan to pay what the court has ordered you to pay?
At this point, all I can do is try to work out a budget where I'm putting more per month in. There's no way I can pay $1,500 a month in spousal support. I don't know where that number came from, but
Came from the court?
right. Yeah, and I don't know how Ms. Mortensen's attorney came up with that number, but there's no way I can pay $1,500 a month. That's not even within my means at this point.
Okay. Can you, are you in a position to increase the amount that you're paying each month?
I could, yes.
Okay. What do you think would be a reasonable amount?
I mean, 500, 600 maybe would be doable at this point. And then I'd like to get Ms. Mortensen taken off of the credit card account, and then I can start making the payments on that.
Yeah,
I'm not even sure.
Yeah, with that, you can talk to Ms. Bliss and make some arrangements. Possibly, at least the two of you can talk about that. I think any effort to show compliance with the court order, an increase of payment is better than nothing. So, what the court is looking for here is compliance with its orders. And if you feel that there's, so if the court is expecting that each month you'll be paying the court ordered spousal maintenance award plus the contempt order. So additional funds should be going to that also. So Mr. Zandy, are you asking for attorney fees for today?
Yeah, absolutely. And I would just point out that I'm always kind of incredulous to the argument of, well, I could pay 500 or 600. I think that's reasonable. But over the past 3 months, he's paid $200, which is roughly the equivalent of his phone bill. I mean, that's kind of the issue that we have with this. Court made pretty specific findings. We've been here several times, not me personally, but Ms. Bliss in our office has, and it's the same kind of go around. So I would just point out that the frustration from my client's perspective, Ms. Bliss's perspective, and now my perspective is when you get the someone lamenting about how they don't have enough money, but they've got a truck payment and a phone payment, some of these other things, and say, well, I could pay $600. I just haven't been doing it. So I think that kind of flies in the face of reason. I know we don't typically like to throw people in jail, but I think Mr. Mortensen needs to come up with a very solid, identifiable plan to keep himself out, because it seems to me, after my review of the history, to be kind of a somewhat of an epidemic with him.
Okay. And all right. So what I'd like to do, Mr. Mortensen, we're going to come back on the third Tuesday of next month. The third Tuesday. Let me just pull that up so I have my calendar. At 9 a.m. What I'd ask you to do, Mr. Mortensen, is to submit something in writing to the court where it shows your budget and where you're making some cuts or reductions from one category and increasing that to the other category of the court orders. So we'll be looking to look at that very closely. So your plan to make payments satisfying the court order will be reviewed on that date. At this point, I will award attorney fees of $350 payable to Ms. Bliss's office. And then we'll see you on the 16th of May with your specific plan of reducing costs in one category and increasing costs or increasing payments to the court orders. And that we'll take a close look at that. I think I joined the hesitation of Mr. Zandy as far as incarceration, but what I'm looking for is some serious budgeting analysis of what is necessary and what you can do to get by without to comply with the court's order. So we'll see you on that date. Ms. Bliss, did you receive a copy?
I did not, Your Honor, and as of the day, yesterday during court prep, I did not see it in Odyssey either.
When I checked last night and I'm checking now, it's not in the court file. So we were here on the 18th of April, and it was clear that we needed to have that proposed budget so we could have a clear idea of how we're going to move forward with this case as far as the spousal maintenance award. So, Mr. Mortensen, do you live in town, out of town? Where's your residence?
I'm in Idaho.
Okay. All right.
I can get that recopied and sent out by the end of the week again.
Okay.
Or if I can email it to somewhere, if that's a possibility.
Yeah, I think email would be appreciated. If you could send the hard copies to Ms. Bliss and also to the court clerk, and then also send via email to Ms. Bliss and also to my assistant. And
Okay.
I'll put in the chat function my assistant's email address, so you have that.
Okay, that will be good.
So bear with me just one moment. I'm just going to send it directly to you instead of just advertising that to all. Are you comfortable with that, Ms.
Okay.
Bliss?
Yes, that's fine, Your Honor. Thank you.
Okay, so Stephen Mortensen, let me just go there and I'll type it in there and then I'll confirm that you received it.
Okay.
Okay, I just sent it.
Yes, sir. I have it now.
Okay, great. I won't be here. We don't have a docket next week. The 30th, I won't be here. And so the next available date would be on June 6th. So we could look at setting the review of the budget so we can assess his plan to comply with the spousal maintenance award. How does that date look for the parties?
That's fine.
That's fine
That
with me,
works
Your
for
Honor.
me.
Okay. All right. So, Mr. Morrison, if you'll quickly get your budget sent out to the parties, including myself and Ms. Bliss, and do that hard copy and also email that would facilitate us having that review.
Okay.
And then let me just ask just a follow-up question. There was from our last hearing, there's an indication that, the court ordered that Ms. Mortensen be removed from the credit card. Has that taken place?
I'm getting on that today. I've tried to get a hold of the person at the bank that I have been directed to, and she has been unavailable for the last week or so. And so I'm going to try to get on that today and get that taken care of.
So, Mr. Morrison, I'm concerned about that statement. We were here on April 18th and the court ordered you to take action, and you took action last week on basically 3 weeks after the fact. I'm concerned about that. Why didn't you do it earlier?
Just busy. I don't have an answer for you, sir. But I'm going to take care of it, and it will be in my name only. And I'm going to try to do it today and get it all taken care of and done, and get them paid on that.
I would strongly encourage you to remove the word try and be successful and complete that today.
Yes, sir.
I'll be looking very carefully to see when she was removed from the card. If it's not today, it better be the next day. Take action and take it quickly. We're not messing around here. When I make an order, I expect you to comply with the order. And I'm concerned that you didn't submit the monthly budget. I understand the mail may be an issue, but the U.S. mail is pretty darn reliable. Things do happen, but in my experience, sometimes people don't submit it. And so I'm not saying that didn't happen with you or did happen with you. I'm a bit skeptical just because of your lackadaisical approach to the credit card and the order that I imposed. So that's enough for today. And we will see you and all of the proof that you've removed her from the credit card and proof that you've submitted the proposed budget to both my assistant and to Ms. Bliss and to the court clerk. We will see you on June 6th at 9 a.m.
Okay. Thank you, Your Honor.
Ms. Bliss, any final items?
Were you going to enter my order as it was presented, maybe changing I don't know if Your Honor wants to change the due dates for removing her from the card and preparing his budget, since it wasn't by today. That was the initial order of the card, but I don't know if you want to change that or leave it as is, and then we'll just come back on June 6th.
I'm gonna leave it as is.
Okay.
And sign off on that. Mr. Mortensen, did you receive that proposed order that Ms. Bliss prepared? The title is Order on April 18th, 2023 hearing.
I believe so. I know I got the $350 attorney fees.
Yeah, that's the one.
I did.
Okay. And do you have any objection to that order as being an accurate representation of what happened on April 18th?
No, that's what happened.
Okay. I've signed off on that proposed order and I'm handing that to the clerk for filing.
Thank you, Judge.
All right. We'll see everybody on June 6th. Thank you.
Thank you.
Ms. Bliss is present. She represents Brenda Mortensen, and I'll ask if Stephen Mortensen is on the line. Stephen Mortensen.
Yes, sir. I'm here.
Okay, welcome. And Ms. Bliss, is your client present?
No, I don't believe she's present. I don't see her on the Zoom again, though. I do typically give the YouTube link.
Gotcha. Yep. Thank you. All right. So on the Mortensen matter, we are here today related to a presentation from a hearing back on April 18th. And we're also here to make sure that Mr. Mortensen had submitted his budget by May 16th. And also to make sure that Ms. Mortensen had been removed from the credit card. So I have a proposed order that Ms. Bliss prepared, and I'll ask Mr. Mortensen if you received a copy of that proposed order. Up in the right-hand corner, it reads Order on April 18, 2023 hearing. Do you have a copy of that?
I don't believe so. What was
And Your
the,
Honor,
what
can
was the
you
order?
double check? Sorry.
That's all right. What was the order for?
It was an order that memorialized what happened on April 18th. That's where I imposed $350 of attorney fees and indicated that it ordered you to submit a proposed budget by May 16th, and it required you Ms. Mortensen to be removed from the Red Canoe visa by May 16th.
Yes, I did receive that. And as far as the Red Canoe visa, everything is in my name. Her name is still on the card because I was unable to pay the $3,200 that they wanted to open a new card in just my name. But all of the billings and everything is now coming to me, and an account has been set up to pay monthly on that Visa card.
Okay, so as far as the proposed order, you've seen that order. Do you have any objections to that order on hearing from April 18th?
No.
Okay, I'll sign off on that and I'll write in here approved via Zoom and the signature line for Mr. Mortensen. Okay, so let's go back a little bit then. As far as the budgets being submitted, Mr. Mortensen, you were ordered to have that submitted by May 16th, that you didn't comply with that. You sent it on May 1st or June 1st. Why didn't you comply?
I didn't have the budget done because I didn't have the order, the credit card fully taken care of. So that needed to be put into the budget that I sent. And once I got that taken care of, I wrote up the budget and sent the budget.
Ms. Bliss, did you receive a copy of the budget?
I did receive, your judicial assistant had forwarded me the submission of Mr. Mortensen, and then I did receive it via first class mail yesterday afternoon as well.
Okay. And then just reviewing that, Mr. Mortensen, your budget for food, the $850, is that for one person or for multiple people?
That's just for one person, Your Honor. I have type 2 diabetes, and the stuff that I need to be eating is getting expensive, very expensive.
You have specialized foods that you consume?
Lots of vegetables, and if I have meat at all, it's very lean meat because I have high triglycerides also. So it's a semi-specialized diet, yes.
You eat $30 a day of vegetables?
Between breakfast, lunch, and dinner, probably pretty close. Yeah.
In what part of the world do you live?
I live in Idaho, North Idaho.
Okay. Okay. So we have the budget, and then the order that I just signed indicates that Ms. Mortensen was to be removed from the Red Canoe visa. Basically, she's removed and it remains with you. And did you do that?
Yes, sir. She has not been removed. They wanted $3,200 to set up a new card in just my name and cancel the other one. And I don't have $3,200 to pay up front for the new card. So she is still on it, but all of the billing and everything is coming to me. And I have set up a direct pay and auto pay out of my personal savings account, checking account, to be paid every month. I believe on the 25th of every month. So I have taken over responsibility for the card. However, she is still on it until I can get it paid down enough that I can switch it over to a new card and take her name off.
Did you explore with the bank ways that you can comply with the court order that her name would be removed? Because that's what I'm requiring. And so I'm sure that there's ways that you could do that. Did you what avenues or options did you explore with the bank?
The only avenue that I was offered from the bank was to cancel the current card, open a new credit card account, and that is what was going to require me to pay $3,200 up front before I could get the new card.
They wouldn't transfer the balance to a new card?
No.
Why not?
Because they would only give me $6,500 in credit, and there was $3,200 left owing that I was going to have to pay up front before they would issue the $6,500 credit card.
So the balance is $9,700?
Just something like that, yes.
So what do you do to plan to comply with the court's order?
Get it paid down as quickly as possible. I'm paying $350 a month at this point. Get it paid down to a point that they will actually issue me a new card and cancel that one, close out that card.
Okay. Signed off on the order. There may be a motion for contempt brought in the future. I don't control that. Ms. Bliss, do you have any additional items?
Your Honor, I was going to make an additional request for attorney's fees, as you're aware, we were here in April on that motion or review for that initial motion for contempt, which was filed back in December to get compliance with the order. Mr. Mortensen wasn't prepared to comply with that order at that time. Your Honor made the ruling that he was to provide the budget and to get my client's name off of the card. We were back here again in May. Still, there were no efforts made. And then now we're back again today and partial efforts have been made. My client has expelled a significant amount of attorney's fees, having attorneys appear at now 4 different hearings just to get him to comply with the court's order back in September. So I am making an additional request for attorney's fees at this point.
You have an amount?
I can get you a fee affidavit, or I can throw out a number of $750.
All right, thank you. Mr. Mortensen, do you have any comment on that?
No.
I'll impose $500 of attorney fees. So Mr. Mortensen will need to pay that to Ms. Bliss's office.
Okay.
Any additional items, Ms. Bliss, at this point?
Nothing further, Your Honor. I'll throw that into an order and send that over for your signature.
Okay. All right, very good. Mr. Mortensen, any additional items?
Not at this time, sir.
All right, that'll conclude the hearing for today. Thank you.
Sorry, Judge.
Need a tech team.
And do we have Stephen Mortensen?
Yes, I'm here, Your Honor.
And Ms. Bliss, has the money been paid?
No, Your Honor. As with clockwork, Mr. Mortensen is paid $200 as opposed to the $1,500 that's been ordered by the court. I think this is our 6th hearing in this matter. Previously, Judge Evans has ordered Mr. Mortensen to provide a budget as to why he can't pay. He provided a budget. Judge Evans questioned that budget, indicated it was grossly inflated. And here we are again with $200 in payments for the last 2 months, as opposed to the $1,500 per month. At this point, unfortunately, given the fact that we've been here 6 different times, this has been pending for 7 months. Mr. Mortensen has been fined with significant sanctions and attorney's fees. That seems to have no effect on him. So at this point, I'm asking that he be ordered to report to jail.
Mr. Mortensen,
Yes, sir.
what do you want to say?
I submitted a budget. It's a good budget. I was just informed about a week and a half ago that my rent is going up at the end of August. And I'm doing what I can. I work every day And, I have bills, and I don't have an attorney because I can't afford one in this case. I don't know what else I can do to satisfy this $1,500, which, as far as I can consider, it's completely unfair, considering that Mrs. Mortensen ended up getting all the proceeds from the sale of the house and all the furniture. And I'm just trying to live and make it, and I don't know what more I can do. I can't get overtime. I can't get a second job. I'm too old for that, and I've been there and done that, and I'm doing the best I can right now.
Ms. Bliss?
And Your Honor, the court found back in September of last year that my proposal of $1,500 a month in spousal support was appropriate given the financials provided. He never filed a motion for reconsideration or anything, hasn't filed a motion to modify that order, just simply chooses not to pay it. I don't know what else we can do at this point.
Mr. Mortensen, whatever bills you've got, you only have one bill that can put you in jail if you don't pay, and that's this one. You think maybe that ought to be your priority?
I guess you do have a point.
I think I do.
Yes, you have a point.
Okay, well, here's where you're at. You're lucky because I'm just filling in today for Judge Evans. If that were not the case, I would be putting you in jail today. Do you understand that?
Yes, sir.
So I'm continuing this 1 week when Judge Evans will be back here. I would assume that if we are in the same position we are in today, Judge Evans will put you in jail. I don't know how to make it any clearer to you or to make you understand the jeopardy that you are in. My assumption is that if we're in the same position next week, you are going to jail. So you should prepare yourself. That understood?
Yes, sir.
Okay, review it the 25th at 9 o'clock. I suggest you figure out how to get this paid.
Thank you, Judge.
Okay, thank you, Your Honor.
Brenda Mortensen and Stephen Mortensen. There we have Ms. Bliss representing Brenda Mortensen. I'll ask if Stephen Mortensen's on the line this morning.
I'm here, Your Honor.
Okay, welcome, Mr. Mortensen. Welcome to Ms. Bliss. We're here on the pay or appear docket, and this is based on a order from, just one moment, September 27th of 2022, because there had been outstanding, longstanding, repeated issues related to payment. And I did receive and review information that Mr. Mortensen filed related to monthly expenditures and the like. And so I'll turn to Ms. Bliss first to give it an update as far as what the payment has been. There's a maintenance order from September of $1,500 a month. And then there was, I guess, the January of 2023 was the pay or appear order. So I'll hear from Ms. Bliss and then we'll hear from Mr. Mortensen, please.
Morning, Judge. We were before the court last week. Judge Warning was covering your docket. At the time of last week's hearing, my client had received $200 for the month of July. At that point, Judge Warning last week instructed Mr. Mortensen to essentially figure out his priorities. The discussion, and I made the request last week that it's clear that fines, sanctions, continued hearings are not making Mr. Mortensen realize his obligation and fulfill that obligation I did make the request for jail time last week. Judge Warning indicated to Mr. Mortensen that he needed to get his priorities straight, for lack of better words, instructed him to make a payment before we came back this week to be in front of your honor. My client sent me an email this morning indicating that no additional payments have been received. I did receive 6 different filings from Mr. Mortensen yesterday via the mail. I haven't had the opportunity to review those, but I would just note that instead of making any sort of payment to show any sort of good faith, he simply is filing additional documentation with the court. My client is incurring additional attorney's fees every time we're before the court for his willful and intentional violation of the court order. As I indicated last week to Judge Warning, there's never been a reconsideration or a motion to modify that order before the court. Mr. Mortensen just clearly thumbs his nose at the order and throws his hands in the air and says, I can't pay it. The court previously found that he could. And so we are asking the court, at least at this point, to order Mr. Mortensen report to jail. Like I said, it's clear that sanctions, fees, judgments, none of that seems to matter to him. I think maybe spending a night in jail might help him get his priorities straight. So at this point, we are asking for a bench warrant to be issued or for Mr. Mortensen to surrender to jail. Additionally, like I said, we've continuously been before the court every single month on this pay or appear docket. He's continuously paying $200 per month and saying, I can't pay anymore, I won't pay anymore. So we are asking for additional attorney's fees. We've had several judgments in this matter. I don't know what good that's going to do, but again, we are making another request for attorney's fees as my client is paying my services to be here every month to ensure some sort of compliance with this order.
Thank you. Mr. Mortensen?
I don't feel that it's a willful disrespect to the court of not paying. I'm doing what I can. I'm working the hours that I'm able to work. The only way that I can see that I can make a $1,500 a month payment is to get some kind of a loan every month from a bank or something to make that $1,500 a month payment. There will be an appeal filed at some point this week. But I don't see that spending any time in jail is going to help my financial situation to be able to make these payments. I do have a check in the mail for Miss Bliss for the attorney fees that I owe. I understand that I am ordered by the courts to pay this. I just can't.
Can I ask you a question,
I
Mr.
just can't. Yes, sir.
So tell me what cuts and reductions and decrease of spending have you implemented since the order was entered, and what the further cuts and reductions have you made to your budget?
I've in the papers that I sent, my food costs have been reduced, and I'm not sure what else. There was a couple other things that were cut out, and I mean I've cut back as far as I can. I have.
So you specifically mentioned food. What else?
I believe there was that I've cut out my $12 a month music fee, and there was a couple other things to help to lower my monthly costs. I've got truck payments and rent payments, and my rent payment has been reduced because I've moved in with some friends, and so I'm paying 1/3 of the rent. And I'm just, I'm trying to do everything I can to get it down, but there's no way that I can come up with $1,500 a month. That's almost half my monthly income at this point.
So I'm showing that you received a $5 raise not too long ago, and you make $28 an hour. Your gross, that puts your gross at about $5,800, puts a net at about $4,300. And that's about $536 more per month than your financial statement indicates. So you indicate also that you spend $700 a month on gas and auto maintenance, $350 just for lunches, and then you spend $200 on recreation clubs and gifts. What cost reductions have you made in those areas, if any?
My recreation, I've cut back on that. The gas is going to be pretty close because the gas prices keep going up, and I've got to get back and forth to work and like that. So, the gas.
My apologies. Go ahead, Mr. Morrison.
I'm trying to cut back on everything. There are certain things that I can't cut back on, my medications, and I've cut back on my food budget as much as possible in order to keep up with my food recommendations. And
from when Judge Warning indicated that you should make a payment between now or 1 week ago and now, have you done so?
I have not. I did not. He just told me that I needed to get my priorities straight. I don't believe it was mentioned that I needed to make a payment in the past week. I can make a payment, not of $1,500, but I can make a larger payment.
Percentage-wise, when you do a percentage of $1,500 and $200, because that's kind of the pattern has been, is that you pay $200 of the $1,500, which is what does that come out to be percentage-wise? About 13%, 14%.
Okay.
And you've reduced your rent by, you said, by 2/3 or 1/3, so that's at $250 there. If you were to reduce your expenses by 50% of just gas, work lunches, and recreation, that would be an extra $625. You've reduced those costs by 25%, that'd be an extra $300. You've had a $5 an hour raise, which is an additional $500 a month. We're getting pretty close to $1,500. So Mr. Mortensen, you can tell me what you would prefer. Either I issue a bench warrant now, or you show up in Kelso, Washington next week to plead your case. Which do you prefer?
I guess I'll have to show up in Kelso.
Okay. You're ordered to appear in Kelso, Washington at the 9 a.m. docket on August 1st. Pack your bag because there's a strong likelihood that you'll be going to jail for your willful failure to pay the ordered maintenance. If you, between now and then, if you're able to readjust your priorities and come up with a real clear plan of how you're going to make this payment on a regular and continuing basis, you're free to do that. The one thing I think is important to remember is that when an order is put into place, then if there's difficulties with that, or if you feel that it's in error, there's means and avenues which you can address those issues. One which would be a motion for reconsideration. Another one would be take a fresh look at this. Things have changed. You've done none of those things, and this order's been in place since September. We're now July. We're fast approaching a 1-year time frame, and there's just been a consistent non-follow-through of compliance with that court's order. When I went through your budget, I went through it very carefully. I went through pleadings very carefully and spent a lot of time on it last night. And I think there's some wiggle room, and when there's a will, there's a way. And so far, I don't think the will is present, and that's why there's not a way. So we will see you next week in Kelso, Washington, 9 o'clock in the morning on the 2nd floor. We'll see you then.
Is on Tuesday, sir?
Yes, sir.
Okay, thank you.
Thank you. So we're on first off, there's one matter that Mr. Mortensen filed. It looks like is a motion to vacate judgment and attorney fees regarding the sale of the home and the like. So that one, just so you're aware, that one is not going to be heard today because the local court rule requires at least 21 days notice for any motion
Okay.
So you need to serve the other party, and then within thereafter 21 days, then the matter could be heard. If you want to look up,
I need to file this with the clerk, is that correct?
yeah, yeah, I know you filed some things already, and that's in my system.
Okay,
So if you need to look at the timeframes, as far as filing, you can look up Calais County Local Rule 88. So if you go to the Calais County Superior Court website, click on local rules, and then look for rule, I believe it's 88, and that'll give you the guidance as far as timeframes. So I just wanted to clear that we won't be hearing that motion today because it hasn't been properly served upon the other party and sufficient times haven't transpired. So the other item that we're here today is on the pay or appear docket. So back in January of this year, the court set a pay or appear, which basically means that either you pay the required maintenance each month, or if you don't pay the required maintenance, then you appear in court and explain why and what's happening. And that's based on an earlier September 2022 order that requires a $1,500 a month maintenance payment. We were here not too long ago, I think it was a week or two ago, and I indicated to Mr. Mortensen that based on the past history, that I could issue a bench warrant, or he could come here and talk in person about what's happening with the payment of the maintenance. So in reviewing the January 10th contempt order, that's where the contempt was found, and that's where you're placed on the monthly pay or appear docket. And so paragraph 10 of that, it says jail time, it says it does not apply. So because of that, I was concerned that there may not be full notice to you that the jail time's on the table. I think it is. We've talked about it. We talked about it last time we were here about a bench warrant or come here. But because that paragraph 10 said jail time does not apply, I'm giving you notice here that jail time is officially on the table, and that it can apply. Because you are facing the potential for the loss of liberty, you're facing jail time for failure to follow that September 2022 maintenance order. You do have the right to have an attorney to represent you and help you through that process. And if you're not in a position to hire one, I'll appoint one at no cost to you. So do you want me to appoint an attorney? Do you want to hire an attorney?
I'm going to have you appoint me an attorney.
Okay, I'll do that. I'll appoint a member of the Office of Public Defense. Before you leave here today, we'll give you a piece of paper that has their phone number on it, so you can be in touch with them. We'll notify them that they've been appointed so they can represent you. And so my plan is I won't be here next week, but I want to set it to 2 weeks from today to August 15th at 9 a.m. to review with the attorney present to determine if you go to jail for contempt for failure to pay maintenance. My plan was today, I invited the deputy to be here today because my plan was to put you in jail today. But I thought a better course would be to give you full notice and because that order said jail time does not apply, I'm hereby notifying you that jail time is a potentiality. And jail time is because a contempt, the whole purpose of a contempt is to encourage a person to comply. And when we try things that don't work, and then eventually, kind of the big one on the table is jail time. And if that doesn't work, I'm not sure what does, but it's an encouragement or a tool to ensure that people are following that. So that's kind of the plan at this point. So we'll make sure you have that phone number, and then I'll just hear from Mr. Zandy if he has any comments.
No, I don't believe I do, Your Honor. I would just ask, I've been looking through Ms. Bliss's orders. What was the date of that order you're looking at for the contempt about the jail time?
January 10th, 2023 is the contempt order. And that's
Okay.
the one, it's placed it on the pay or appear docket that's the source of that also.
Okay.
And then Mr. Morrison.
No, thank you for that clarification. I don't have anything else to offer, Judge.
Okay. Mr. Mortensen, do you have any questions?
So as far as the pay or appear, all the paperwork that was sent, field financial source documents and all that, I'm going to need to get that to the appointed attorney.
It needs to go to the opposing counsel. So Ms. Bliss.
It has.
Okay. So that's where it needs to go. And if it's already gone there, then you just need to file a document called a return of service or a declaration of service or affidavit of service that indicates that you've served those documents on the other side, and then file that declaration or that affidavit.
Okay,
Any other questions?
I think that's it.
Okay, let me find that document that has the phone number of the attorney.
And that the date of the next hearing is August 19th,
15th, 2 weeks from today, and
15th.
it'll be at 9 a.m. Our efforts today. I'll make sure that before you leave, I'll just pull it up here in a second and give you that phone number. Any last items or questions?
The August 15th, that's going to be up here in person.
Yes.
Okay.
Correct. All right. So if you have a phone number or a pen ready, I'll give you the phone number to the Office of Public Defense, and I'll give you their address also.
It's very
So
close.
let them know that the court's appointed them to represent you, and they can get you set up with an attorney.
Okay.
Okay. All right. Thank you.
And we have Mr. Angelico here in the courtroom with his client. All right, so did the $350 get paid?
No, Judge, and the order is actually for $1,500. And today it's pursuant to my email from my client last night, the $200 that Mr. Mortensen has historically paid has not been paid either. We were before Your Honor about a month ago setting this matter in motion as to the potential for jail time. Judge Evans took some pretty special precautions and notified Mr. Mortensen that it was in fact on the table, appointed counsel for Mr. Mortensen, and to date, no payments have been made.
Mr. Angelico?
Thank you, Your Honor. Mr. Marr was appointed to this case, Your Honor, and unfortunately he is not able to appear today as he's on vacation this week. I'm here on behalf of Mr. Marr. Mr. Marr is requesting that the Office of Public Defense be allowed to withdraw in this particular case. There are several bases for that, Your Honor, in that we are primarily attorneys versed in criminal law, Your Honor, in the criminal rules. We have no attorneys that are versed in family law, civil rules, civil court rules, or civil cases necessary to give Mr. Mortensen effective assistance of counsel. Our office also would have to account for this case under the caseload standards, as we are short-staffed. Mr. Marr and any other attorney do not have the time required by this case to represent Mr. Mortensen. At one time, our prior director did have us contracted in civil case to do minor and adult guardianship cases. We were under contract. There was funding under that contract. A large majority of those cases were sent to private family law attorney to handle, various private family law attorneys, local area to handle. Unfortunately, under this case, we do not have funding necessary to contract this case out to a family law attorney. It may seem straightforward that it's a criminal contempt, whether he's jailable. However, I think this case is intertwined with a dissolution case. For example, Mr. Mortensen, I think, has filed a motion that has not been argued because of, I think, the notice requirements, which addresses in part his income, monthly living expenses, and also an argument concerning an offset of equity there was equity in the family home from the sale of the couple's residence that has not been accounted for. That I think Mr. Mortensen is in his motion is basically saying that he would be doing offset because she has taken this portion of the equity in the home. This is a temporary, under temporary orders, Your Honor. This is not a final dissolution. And we believe that Mr. Mortensen needs to be represented by somebody versed in family law, since it's kind of intertwined with the other issues. And I believe that certainly, I think his motion needs to be heard first if there's any question about offset of that equity. I would note that we have had contact with Mr. Mortensen. I did do a cursory look when Mr. Moore indicated that he would not be available, but it's interesting to note, I think on the original order that ordered the spousal support was a notation by Judge Evans something to the effect of that, that it would be reviewed, or there would be a look when the final dissolution of assets occurred. So, I at this point, Your Honor, we would argue that Mr. Mortensen needs to be appointed somebody versed in family law that would be able to compile all of the parts of this case necessary to defend him, and we're just not capable, Your Honor, I don't believe, to effectively represent him in this area.
Mr. Mortensen, do you have any objection to the motion of the Office of Public Defense to withdraw?
I do not.
All right, I will allow him to withdraw. Okay, here's where we're at. Mr. Mortensen, as I told you last time, jail is on the table. It appears since that time, you have chosen to just ignore that. So what I'm going to do is this. Have a seat in the back of the courtroom. I'm going to go figure out who we are going to appoint to represent you. We're putting this on for next week on this same docket. And I suggest you have a long conversation with whoever that attorney is. Because if I were deciding this today, you would be sitting in jail until you pony up, however long that takes. You understand the jeopardy you're in?
I understand,
All
Your
right,
Honor.
have a seat in the back. And I believe all that leaves is to address Mr. Mortensen's issue.
Your Honor, I failed to, is the court going to do a bench order that allows OPB to, this morning OPB to be.
If you would fill that order out and just leave a blank for so-and-so appointed in your stead, and I'll go back and try and find out who we can appoint. Okay, so I have Mr. Morgan's office on the line. Please let Mr. Morgan know I'm appointing him to represent Stephen Scott Mortensen. The case is Mortensen and Mortensen. The matter is a criminal contempt. Did you get all that? Pardon? Okay. I'm also going to instruct Mr. Mortensen to call Mr. Morgan's office immediately. And the matter is on next Tuesday, the 22nd at 9 o'clock. So, Mr. Mortensen, you need to call Daniel Morgan's office. I'm not sure who the attorney is who will be representing you. You need to call him immediately, get in to see him immediately, because a week's not a whole lot of time given what's going on. You understand that?
Yes, sir. Mr. Mortensen, it's a 6-hour trip over here.
I'm sorry?
Mr. Mortensen lives at Idaho, Your Honor, so it's a 6-hour trip over here.
Well, he needs to talk to Mr. Morgan about that, and we'll see where we go. But right now, he's due here in person next week, unless a judge says otherwise.
We'll request that welcome Mr. Mortensen, and you can also go by Mr. Morgan's office before he leaves back.
I think that would be a real good idea.
Thank you, Ian. Thank you.
Okay, so that brings us to the Mortensen matter. Mr. Lee had communicated with the court earlier. He indicated he's in 2 different dockets this morning, so he's going to get here as soon as he can. So, Ms. Bliss, you're here, and you're representing Brenda Mortensen, correct?
That is correct.
Okay. Just so you're aware, Mr. Stephen Mortensen is in the courtroom. He's present, and then we're just waiting for the arrival of Mr. Lee.
Okay.
So maybe what we could do, we could check in 10 minutes at 9:30, see if Mr. Lee has experience. If he comes in a little bit earlier, would you be available, or do you want to just shoot for 9:30? Okay.
I can stick around, Judge. Whenever he appears, I can appear.
Okay. Well, let's just kind of set a time frame of 10 minutes. We'll come back at 9:30, touch base, and then we'll go from there. We're here in the matter of Brenda Mortensen and Stephen Mortensen, 223-38808. We're here on a continued pay or appear docket related to spousal maintenance. Mr. Lee was appointed, I think on the 15th of August, and he's here. And I just want to touch base with him to see if you've had an opportunity to confer with Mr. Mortensen.
And Your Honor, I and Mr. Morgan have had some opportunities to talk with Mr. Mortensen. We are aware that he's filed paperwork essentially going against the original order, but he is trying to take care of his obligations under that order. He brought with him today, it looks like a deposit receipt from Chase. It indicates that the transaction of $1,300 for the maintenance will go through as of next week. He also brought with him checks for Ms. Bliss as far as attorney fees. So it does appear we're attempting to cure, though we haven't successfully done that yet. What I would just request, given the recency of my appointment, as well as the fact that he is making progress on the payment, if we could set perhaps another review in a couple of weeks, make sure that those payments go through, and then we can potentially strike this hearing.
All right, thank you. Ms. Bliss?
And Your Honor, I think you're very aware of my position in this matter. We've been before the court for the last 8 months on this contempt issue, a frequent pay or appear docket. Mr. Mortensen has come in person. This is his 3rd time in the last month. Not one of those times has he ever brought a check to my office. Not one of those times has he paid my client the amount that's owed under the current order. I was prepared to tell the court today that he did make a $200 payment, which is consistent with his past practice. And that payment was made on August 15th. While it's great to hear that he's got those checks, I think I still believe that jail time is appropriate, at least for nothing else than to teach him a lesson that we've been before the court numerous times. He's had plenty of opportunities, but for today's hearing of impending jail time, those payments were finally made. I'm concerned that if Your Honor doesn't go follow through with that fair warning that both you and Judge Warning have given him the last month, that this is just going to be a continuing issue, and we're going to be back before the court in that review hearing in a couple of weeks, as Mr. Lee has requested, and we're going to be in the same position requesting the support be paid in full again. But I'll defer to the court. I will also ask the court for another contribution of attorney's fees. Again, this is the 3rd hearing in the last month that my client has had to pay for my attendance simply to get Mr. Mortensen to comply with the court's order.
Thank you. Did last week, I don't think Judge Warning awarded any attorney fees for the last court appearance in which he was present?
No, Your Honor. Mm-mm.
Then the prior one, there was not any award of attorney fees, correct?
Correct.
Okay. Mm-hmm.
Your Honor, could I briefly respond?
Yes, please.
I do just want to indicate the substantial change in circumstances that's occurred recently is my client has taken out a loan to essentially pay these fees. He's indicated that the interest rate is quite high. Frankly, I've been appointed at state expense. I don't believe my client in normal circumstances is capable of making these payments, but he is trying to stretch and use whatever resources he has to try and become compliant. So again, I do believe things have changed in the recent days.
Well, let me just share just a little bit of kind of my analysis of what's going on here. So there was a spousal maintenance order entered in September of last year, 2022, an amount of $1,500. Since that time, there was difficulties, and in January 10th of this year, there was the pay or appear order to appear on a regular basis to see why Mr. Mortensen was paying or not paying, or not paying. If he wasn't paying, he would explain why. And there's been a consistent pattern of non-compliance. He's been paying roughly $200 a month for many months. And when I took a look at this, I thought it was very interesting that he received a $5 an hour pay increase on January 1st of this year. So his gross previously was $4,800, and now it's about $5,800. So his net income increased at least $536 a month. And there was still no increase in maintenance being paid by Mr. Mortensen. Also, there's no showing of any belt tightening, if you will, because it's very difficult when people go through divorces. There is not enough to go around, but yet there needs to be at least some showing of belt tightening. And so what I heard from Mr. Mortensen last time is that he's concerned about his health, rightfully so, because he's diabetic, and that he spends $350 a month for work lunches, which if a person is really interested in complying with a court order, they're going to make some adjustments to that. And that means that maybe they would cook in the evening and bring their food for the lunch the next day. And they could dramatically decrease that cost for the work lunches. Recreation, the same thing. Mr. Mortensen talked about fishing, how that was really important for not only his mental health, but his physical health. He said that was very important to him, but yet there's been no showing of any belts tightening there. There's an indication that his vehicle, it's important where he lives to have good tires on his vehicles to get to and fro. And yet there's still $700 a month in his budget for gas and auto maintenance. No showing of any belt tightening. So if there was a reduction of even 25% of those three items, that's $312. And if you add that to the net income increase of $536, that's $848 a month of extra money. So you add that to the $200 that you've been traditionally paying, that's roughly $1,000. There's been no showing there's been any effort to increase the even nominally the child's or the ordered maintenance. So even if there's a showing of like $225, okay, this month I'm going to try $230. There's been nothing, zero effort, zero showing of any belt tightening, zero effort that the net income increase that he's received has gone towards satisfying his obligation. How long do you think you should stay in jail until you get the message, Mr. Warrenson?
I don't think that I should be in jail. I did go and get the personal loan. It's large enough that I can pay the back owing. And moving forward, if it's still the case that I owe $1,500 a month, I can come close to that, I believe. I'm, after talking with Mr. Lee, Mr. Angelico, and Mr. Morgan, I have been schooled, and I understand that this is a court order and that I need to take care of it until it is resolved one way or the other.
The $1,300 that was scheduled to be paid next week, do you have what Mr. Lee had mentioned? What date is that supposed to go out and be transferred?
It's already in Chase, and they are holding it until the 30th. I put it in yesterday.
So when you say they're holding it till the 30th, what does that mean?
I have no idea. That it's on the receipt that I got from Chase, that it just says date when available, 8/30/2023.
Is that because it's a deposit clearing time frame?
I really have no idea, because I've never, in any of the deposits that I've made before, it's never come back like this. It's a money order deposit.
And Your Honor, I will indicate on the receipt above that, it says notice of delayed deposit availability. So I believe that is what is indicated on this receipt. It may just be a value situation. If too much money is going out, they might just delay it automatically.
Right. Okay. All right. So in any issue related to contempt, there needs to be a willful and intentional failure to abide by the court's order, which was from September. So since September, there's been a shortfall percentage-wise, pretty significant. I mean, it's the $200 is less than 20%. So it's probably 15-17% of what the court had ordered. And there's been no corresponding increase, notwithstanding pay or peer appearances. There's not been any movement at all for the prior two hearings, and now we're here. So there's an issue about upholding the integrity of the judicial system. There's an anticipation that the courts, when they order something, it'll be followed through. And there's concerns also that if I don't follow through with what we talked about, the jail time, is that integrity or the authority of the court is somehow diminished. And it's not necessarily, it's not this court, meaning it's the entire judicial system. I'm very loath. I don't think I've ever sent anybody to jail for failure to pay. I'm pretty darn lenient with that. What's concerning in this case is that there has been a significant increase in net income, and there's been no belt tightening. I just haven't seen it. And there hasn't been any showing of, if somebody said, hey, I am scraping by, I'm doing this, I'm recycling aluminum cans. I mean, some showing that there's an effort to increase the amount that the court ordered. And it's not even coming close percentage-wise of what the court had ordered. And Mr. Mortensen has the opportunity and has had the opportunity to bring a motion to modify that spousal maintenance award. If he felt that is incorrect, there's opportunities to appeal, there's opportunities for reconsideration. None of those have happened. And so that's why I asked the pointed question to Mr. Mortensen, how many days in jail does he think it'll take for him to understand that this is serious business? When the court orders something, there needs to be effort. There needs to be effort expended to comply. And I guess that's what I'm seeing now. It's almost a year later from when the court ordered this. So there's been plenty of time to adjust schedules, adjust income, adjust spending patterns. And I recognize that spending patterns are difficult. There's obligations that we all have, and it takes time to adjust those. I recognize that. And yet at the same time, there's been no showing of adjustment. And to me, that's the most concerning part, is that that's why contempt is there. It's an effort to help people change their behavior so that they come into compliance with the court order. That being said, there's a indication that there's a personal loan that's been taken out. I don't know the exact dollar amount. Mr. Lee, do you know the exact dollar amount?
I don't.
It was, it came to about $7,500 after the origination fees were taken out.
Okay.
And I do understand that this is an obligation that was put onto me, and I'm trying to make adjustments. As of recently, I don't think I really understood how serious it was, but I do now. And I'm trying to make the adjustments to get the back ordered monies paid, and moving forward to adjust my spending and my budget to accommodate that.
Can you share with me what some of those adjustments are?
Well, like you said, preparing lunches beforehand, the night before, or get up early enough in the morning to do it in the morning. And not doing the truck maintenance and stuff is pretty well taken care of. So that will be cut. Gas, just not going, if I'm going to go fishing or something, not going as far to go fishing, go fishing closer to home, so I'm not spending the gas. Things like that, just like you said, tightening up and meeting this obligation first, I guess.
Okay. All right, so I'm going to award an additional $500 of attorney fees for the 3 instances in which we've been here addressing this in favor of Ms. Bliss's client. There's been multiple payer appearances, dockets, and I think the idea is that sometimes that can be a double-edged sword. We have people come in, okay, I can't pay, and so we kind of nurse it along and say, okay, when are you going to pay? You didn't pay this month, and it gives kind of maybe a false sense of security that pattern is going to continue. That's one way to view it. The other way to view it is like, hey, look, this is an opportunity. We're saying you need to pay this amount, and we've visited on a monthly basis for a long time, and so that's why I say it kind of cuts both ways. One, it may give kind of a false sense of security, like, okay, this is going to continue, and everything's going to be okay. And on the other hand, it shows kind of an exceeding patience, a level of patience and forbearance of exacting what the court had ordered previously. I don't think I can go any further. I'm going to send you to jail today for 2 days. You'll be released tomorrow in 48 hours. And that's just a clear sign that this behavior must change and that there needs to be compliance with the court order. So I'm going to invite a deputy to come up to take you into custody, and then you'll serve the 48 hours, and then you'll be released. And then we will set this for a review on the 5th of September to make sure that that payment of the $1,300 has gone through. And that's unless the payer or the peer. So take a seat, you stay right there, the deputy will be up and then take you into custody. That'll conclude the hearing.
Would Your Honor be willing to prepare a bench order for that $500 attorney fee judgment, or would you like me to prepare one?
I'll do it.
Okay, thank you, Judge.
All right, that'll conclude the hearing. Mr. Mortensen, please remain in the courtroom until the deputies come and taken you into custody.
And Your Honor, his vehicle's in the parking lot. Does he need someone to come pick that up?
The vehicle?
He has a vehicle that he drove here in.
And I also have my medications in the vehicle.
I think the medications are important to get. So I've never seen I've never heard of anybody being towed from the Hall of Justice, not to say that it hasn't happened. You may give consideration to moving your car to the south parking lot. Because there's the one that's right in front of the river. But if you're south of the parking lot or south of the building, that's generally, I think, a more forgiving, and you're not going to draw as much attention. And just park it in an area where it's well lit underneath a light. So once you've completed that, you'll need to be back in the building at 10 o'clock. So 10 o'clock, you'll need to be back here. The deputy's here. So deputy, just so you're aware, this is Mr. Stephen Mortensen. I've held him in contempt, and I've imposed 48 hours of custody. He made a request to retrieve some medication from his vehicle that's parked in front of the hall.
Okay.
And I said, that's fine. And then he's also going to move his car to the south parking lot, and then he'll be back here at 10 o'clock. Welcome, Mr. Mortensen. We're here to review status of the $1,300 of spousal support, if that payment has been made. Ms. Bliss, do you have any information related to that?
I do, Your Honor. I did receive confirmation from my client that $1,300 was deposited and released into her account.
All right, very good. All right, thank you, Mr. Mortensen. Do you have any comments?
Just about the motion that I had filed on the 10th of last month, I believe.
Let's see. I'm looking in Odyssey. I see in August. I don't see any motions being filed. I see.
Okay, maybe
was it earlier?
It could have been earlier.
Okay, so July 27th, it looks like there was an order, or pardon me, a motion, Mr. Mortensen's motion to vacate or alternative fine satisfaction judgment and attorney fees. Is that the motion you're referring to?
That is the one, yes.
Okay. And let's see. I'm just looking to see, usually when a motion is filed, there'll be a corresponding docket notice setting it on the docket to be heard. I'm not sure if that's been done. So without that, there is that pending motion that's out there. So we probably need to set a date to have that reviewed. Ms. Bliss, did you receive a copy of that motion?
I do believe, yes, back in July I did, but as Your Honor indicated, I didn't receive a docket notice. So I, at this point, have been waiting for it to be noted on for my client to provide a response.
Okay. All right. So, Mr. Mortensen, you know, that motion is there. It's a valid motion. It's still pending. What we need to do is get it logged on a particular docket. So usually that's done by preparing a docket notice in conjunction with the court's clerk, clerk's court, the court's clerk, and then providing Ms. Bliss a copy of that, setting it out.
Okay.
A particular time frame, and you have to take into consideration Cowlitz County Local Rule 88 that relates to time frames. So take a look at that. You can find that on our Superior Court website.
Okay.
And then that could be docketed, and we can address that motion.
Okay. Very good.
All right, and then let me double check with Ms. Bliss as far as the continued pay or appear monthly appearance. What is your preference?
My hope is that this last experience maybe has had Mr. Mortensen realize the severity of this. It would be my request to maybe just do one more. Obviously, we did just have him spend some time in incarceration. So my hope is that he can continue to make payments as he is displayed recently. So my request would be setting one more, maybe on the 26th of this month.
September.
And then if at that point he's continued to make those payments, then we can cease moving forward with pay or repair.
Okay, all right, thank you. Mr. Mortensen, any input on that point?
No, nothing. I agree.
Okay. Well, let's do that then. We will set the pay or appear to September 26th to make sure that the payment has been received for this month. And then we'll get a docket notice and we'll be able to understand what the time and date that we will hear Mr. Mortensen's motion.
Okay.
You're the only, sorry, Mr. Mortensen.
No, go ahead.
Okay, and Your Honor, the only remaining concern that I have is at the last hearing, Mr. Mortensen had indicated he had several checks that he was going to deliver to my office for attorney's fees and outstanding judgments and the like, and those were never delivered. I just want to make sure those weren't somehow lost in translation, or if he hasn't provided those yet.
Those will go out today, along with the another payment for the $500 judgment that was made 2 weeks ago, 3 weeks ago, whatever it was. And you should have those by the end of the week.
Very good.
Okay, great. We'll next see everybody on September 26th. Next, let's call the Brenda Mortensen and Stephen Mortensen matter, which is 22-3-38808. Ms. Bliss is here representing Brenda Mortensen. I'll ask if Stephen Mortensen is on the line. Stephen Mortensen. All right, Mr. Mortensen, if you're here, make sure you're unmuted and state your name so I know that you're present.
And Your Honor, I can just report to the court, Mr. Mortensen did in fact make that payment this past weekend, so it's likely he may not appear, given that it is a pay or appear docket. So he did make that $1,500 spousal maintenance payment to my client this past weekend, and I did receive some payments towards his attorney's fees in my office this morning.
Okay, great. Yeah, I think that satisfies the pay or appear portion he paid. So we'll note that he was in compliance. And then we had talked last time that maybe 1 or 2 times more of compliance, then we might reconsider changing the pay or appear. But let's do one more month, and we'll kind of reevaluate at that time. Great, thank you.
That works.
All right, so we'll complete that. So this the next month schedule will be, let's see. So we were doing I guess the last Tuesday of every month.
I think I had initially put in my motion the 3rd Tuesday of the month, but I don't have any objection if we want to do it the last Tuesday of the month, just to ensure that that month's payment had been made at least at some point.
Yeah, I want to make sure maybe if there was a consistent pattern that we had established so that there's no confusion as far as Mr. Mortensen goes. If it was the third Tuesday, then let's probably stay with that. We've probably changed it to this week just because of judicial conference.
I believe so.
So that would put us 17th of October. So we'll set it to the 17th of October for a pay or appear.
Very good. Thank you, Judge.
Thank you. Next, I have Brenda Mortensen and Stephen Mortensen, 22-3-38808. It's the cause number. Ms. Mortensen is represented by Ms. Bliss, and Mr. Mortensen is represented by Ms. Holder. And I'll just double check. Ms. Bliss, are you on the line?
Yes, Judge, I'm present today.
Okay, there you are. And then Ms. Holder, I see that you're on the line also.
Yes, Your Honor.
And just confirming if Ms. Brenda Mortensen is on the line.
I didn't anticipate her today, Judge. I do know that she's working.
Thank you. And just confirming that Mr. Stephen Mortensen is on the line.
I'm on the line, sir.
Okay, welcome to you, Mr. Mortensen. We're here this morning on a motion for contempt regarding spousal support payments and also the Red Canoe, I think either credit card or account, and the IRS debt. So it's kind of 2 motions related to the contempt. So I've read there was the information from Ms. Mortensen And I've read the input from Mr. Mortensen regarding his payment and the check, the cashier's check and the payment plan with the IRS. And then his information as far as debt to income ratio and the refinancing. So I'm familiar with those items that the parties have shared. So I'll hear from Ms. Bliss, your argument, then we'll hear from Ms. Holder, please.
Thank you, Judge. And as you're aware, I do represent Ms. Mortensen in this matter. This matter is of no new, surprise to Your Honor. Your Honor has heard several hearings very similar to this one in the case history. My client, again, had to bring forth a motion for contempt. Within that motion, at the time that the motion was brought, Mr. Mortensen was several months behind in spousal support. So I'll address that factor first. I can acknowledge that a $6,000 cashier check was provided to my client earlier this month. It's my understanding that was for payments. I believe it was March. Nope. My apologies. Those payments caught him up through August. So here we are into August, and my client has not received a payment as of yet. I would just note that for the record. Again, this isn't the first time we've had to bring a contempt. This matter has been in on contempt on several different instances. The court previously had us on a pay or appear docket where we were here every single month to ensure payment. As of the last time we were before the court, Mr. Mortensen was ordered to serve some jail time in order to get him to comply with the court's order. Your Honor entered that order. After being released from custody, he did become current in his support. I believe the next month he was also current in support. So at that time, the court terminated that pay or appear docket requirement in hopes that this good faith momentum would continue moving forward. And unfortunately, we're back before the court with this year having another repeat of last. So for purposes of the support, Mr. Mortensen is technically current as of now, but again, it did take bringing this motion again before the court. The threat of jail time again being placed upon him before any sort of movement was made. As it relates to the Red Canoe credit card, Your Honor entered an order on April 18, 2023, requiring him to refinance that credit card out of my client's name. There was a date certain on that order by 5/16/23. He was to have made arrangements to have that assumed by himself and to get my client's name off of that debt. My client provides for you that debt is over $6,000 in owing. My client's credit is severely impacted by that. There's late payments and the like. Again, my client is asking the court to enter yet another order requiring a date certain in which that debt is to be taken over by Mr. Mortensen to relieve my client of that obligation. As it relates to the IRS debt, I understand the submission by Mr. Mortensen is that he's made payment arrangements to get that debt satisfied, or at least payments being made. At the time of our motion, my client was getting lien notices that there was several $1,000s in outstanding payments, and no payments had been received. Again, this matter had to come before the court on a motion for contempt in order to get any sort of movement by Mr. Mortensen. My client did incur, naturally, fees getting this matter before the court. Again, getting him personally served out of state was a $95 service fee. We're asking for reasonable attorney's fees and costs for having to bring this matter back before the court. Again, I am asking for us to be put back on a pay or appear docket. And I think I have that as the third Tuesday of every month to ensure that we have payment. I'm hopeful that now that Ms. Holder is involved, that we can get this matter moving forward to finalization. But in the meantime, as Your Honor is aware, my client depends on those spousal support payments. And unfortunately, we've had to spend far too much time in the courtroom in order to collect those. So that's our request before the court today. Again, a confirming order as to the Red Canoe credit card and a date certain. Again, we're over a year after that last date certain and nothing has been done at this point. So I would ask that be entered, potentially a review hearing after that date to ensure that it has been completed and for fees and costs.
Thank you, Ms. Bliss. Ms. Holder?
Yes, Your Honor. As Ms. Bliss stated, the underlying issue has been taken care of the $6,000 in arrears was paid. Mr. Mortensen has set up a payment plan with the IRS. Regarding the Red Canoe bank account, Since my firm has come on, we've done a forensic analysis of Mr. Mortensen's bank statements and his credit card statements. We're in the process of looking through all of that. And what we have found, we will be bringing a motion to vacate and or modify spousal support. The court, in the April 18th hearing, it appears was asking questions about his budget and trying to get to the bottom of why in the world he hasn't been able to pay these spousal support payments and pay them regularly and pay the amount that is owed. And we believe that he does not have the ability to pay the spousal support in the amount that was ordered. As far as the Red Canoe card goes, I looked into the pleadings and to see, what initiated that. And he was asking at the time, the first time the Red Canoe card came up, was that Miss Mortensen was using the card, and he asked that she stop using it. And at that point in time, the court said, would it be okay if Mr. Mortensen was able to take her name off the card? And he said, yes, that would be fine. He agreed to that, not knowing the bank would not allow him to take her name off the card. Currently, he is making payments on it, but those payments are low. They are the minimum payment. Sometimes they are late. They are keeping that balance stagnant to the point that he cannot pay it down to allow him to remove her name. Therefore, he is not willfully or wantonly violating the court order. He simply just cannot do it, and the court cannot order the bank to make him remove her name. It's just we're kind of treading water at that point in time, Your Honor. Now, as far as the attorney's fees, I would ask that either they be denied or that they be reserved. Currently, since this case has been ongoing since 2022, August, that is 2 years, this case has been pending. Nothing has been done except contempt motion after contempt motion. Mr. Mortensen has paid over $2,100 in attorney's fees. He has paid $36,000 in spousal support. I would ask that the fees for the attorney's fees either be denied or they be reserved on until we can get finalization. At that point in time, they can come out of whatever the marital assets are. I'm not going to get down into what the marital assets are according to Mr. Mortensen, but it is rather striking that Miss Mortensen took $168,000 of the original the community property that was sold. She then took all those proceeds, paid $126,000 to buy a new double wide outright, park it for $1,200 a month in Woodland to hook it up, and $500 a month for utilities. So she has essentially created this need for herself, and we are trying to dig Mr. Mortensen out the best we can. But as right now, I would just ask that the court dismiss the motion for contempt as he's up as far as he can be. We're working on a motion to vacate and or modify spousal support. And if the court finds it necessary to pay Miss Bliss for her work, I would ask that those fees just be reserved until we can get to finalization, because we're not moving forward because Mr. Mortensen keeps getting brought in for contempt because he is in a financially precarious situation.
Thank you, Ms. Holder. Ms. Bliss?
And I'm not going to beat a dead horse here, but unfortunately, Ms. Holder is new to this matter. Your Honor and I are not. Your Honor spent significant time in prior hearings going through Mr. Mortensen's budget, and it was questionable at best. I remember one point in particular, Your Honor asked how he's spending, I believe it was $800 in groceries every single month. The fact of the matter is there is this order before the court. Mr. Mortensen has failed to abide by that order on numerous occasions. This isn't the first contempt. Had this been the first contempt, I would be more inclined to agree with Ms. Holder that maybe we need to reassess this. But the fact of the matter is, Your Honor has already made a ruling that was a willful and intentional violation of the court order the last time we were before the court. Nothing has changed. What's interesting is while Mr. Mortensen claims poverty, for lack of better words, he always finds a way to come up with the money when this matter is brought before the court. When Your Honor issued jail time the last time, he miraculously overnight came up with thousands of dollars to pay the outstanding spousal support, attorney's fees, sanctions, and the like. What's happened again? I again bring forth a motion for contempt. Miraculously, a $6,000 check appears in my client's bank. So it's very clear that but for bringing Mr. Mortensen to court, threatening him with attorney's fees, sanctions, and jail time is the only way we can get him to move and to follow the court order. This is a willful and intentional violation of the court order, and I am asking the court to find contempt yet again.
Your Honor, if may me respond to the source of Mr. Mortensen's funds. He has taken out bank loans through Best Egg. to pay attorney's fees and spousal support. He has gone further into debt to pay his spousal support. As far as the most recent check, his mother passed away, and that is money from her estate. So unless he has another mother who's going to die to leave him money, I don't think he's going to get money the same way again.
All right, thank you. All right, so I appreciate Mr. Mortensen making the court-ordered spousal support that was previously ordered. So that takes care of the back support, at least up through, I think, July. So so let me just start with the IRS payment. So it sounds like the payment arrangements have been made. So I appreciate that's occurring. And, you know, I appreciate that the cashier's check has been received by Ms. Mortensen. The difficulty is that, you know, the representation here is that there is no payment in February, April, and June. And it seems to me, but for a motion for contempt, those items, and including the IRS payment arrangements, may not have been made. And I think that force is what pushes things forward. And without that, I'm not convinced that the payments would have been forthcoming. So I think is that the motion for contempt was necessary to at least raise that issue to make sure that the order was being complied with. So I'll make a finding of contempt. I'll impose a $100 civil penalty. I'll impose $500 of attorney fees. And as far as the Red Canoe credit card, I recognize that the May 16th order is still in effect from 2023, that'll needs to be removed. Ms. Mortensen needs to be removed from that account. I'm going to hold off a little bit as far as the request to set a date on that, but I am going to require Mr. Mortensen to make timely, never late, minimum payments on that credit card going forward. That order from May 20th of 23 still is in effect, and that still needs to occur. But at this point, I'm just going to make sure that please, Mr. Mortensen, make that the monthly minimum payment timely.
And Your Honor, if I might, there are two orders in place, and there's one for the Red Canoe Visa ending in 5821 and one ending in 2111. Do we know which is the correct card he should be paying on?
So I'm looking at the May 16th, 2023 order that has references the 211. That it says petitioner shall be removed from the Red Canoe Visa ending in 2111. Respondent shall complete this by May 16, 2023. And
yes, Your Honor. And then June 5th, you signed another order that says the card ending in 5812.
June 5.
Yes, Your Honor. It's filed as June 6th, but you signed it June 5th.
Okay. Yeah, I see that. Thank you. So we've got the April 18th and then the June 6th is the filing date, which ends in the 5812. Ms. Bliss, any care to shed any light on that?
I don't know if I have that information as readily available. I would just ask. I think that the intentions are clear. It's the account that my client claims has the $6,098 outstanding balance. I think Ms. Holder and I could real easily figure out which account that is. My understanding was the 2111, but again, we've done minimal discovery at best in this case, so that may not be completely accurate.
Yeah, it's a good catch, Ms. Holder. And I don't know which one, other than if there is a joint credit card account that's in the $6,000 balance range in which both parties' names are on it, that if it's one account, then timely minimum payments. If it's both accounts, then timely minimum payments would be required.
Yes, Your Honor. I'll work that out with Ms. Bliss's office.
Okay, I appreciate that. Thank you. So as far as so I made that finding of contempt related to the spousal maintenance and the IRS payments, and also the Red Canoe credit card. However, I'm providing a bit of leniency on that. So then, as far as the request for pay or appear docket, Ms. Holder, do you want to just address that just briefly? Because I recognize that, you know, each time there's an appearance, there's dollars being expended by both parties.
Yes, Your Honor, I don't think that's going to be necessary. My client has been cooperative with me in my office since I've come on board, and we are in the process of, like I said, going through his accounts and checking his accounts compared to the financial declaration he previously put before the court. And we are going to be filing a motion to either vacate or modify the spousal support. So if we could hold off on a decision on the appear or pay docket, at least until that issue is heard, I think that would be the appropriate course.
Your Honor, may I speak briefly on that?
Please.
I guess my concern is holding off now would require another motion for contempt to be filed to bring that issue back before the court, which obviously incurs additional fees, costs, and the like. My request would be to set us on that pay or appear docket. Again, if he pays, we strike it. Neither of us have to appear. If he doesn't, well, then we're back before the court to remedy the issue that's been at issue for a substantial period of time. Granted, again, if Ms. Holder does bring that motion, when that time comes, we can then at that point strike any further dates or what have you. But I would request that we get something on the calendar to ensure that we have compliance.
Okay, thanks. I think what I'd like to do is set at least just one pay or appear review on September 17th at 9 o'clock in the morning. We'll talk then about if there's a necessity for any further ones. That motion to vacate or modify may have been filed by that time, and so there may be a path forward. So we'll set it for the 17th of September, 9 a.m. As far as presentation on the contempt order, we could set that for a Wednesday morning docket or a Friday 8:45 docket. So I'm not sure if there's a preference. We could take a look at the 23rd of August as a potential date at 8:45.
I have any objection to that? Sorry, Ms. Holder.
I'm free that morning, Your Honor. You say 8:45?
Yes, and let me just make sure. Yeah, Friday the 23rd, 8:45. Let's set up for that date if that works for everybody.
Very good. And I'll circulate an order. I did have one prepared for today's hearing. Your Honor made some changes, so I can go ahead and make those unless Your Honor just wants to do it on the bench right now.
No reason to set a hearing if we can just modify the one that you provided. I overlooked that, so I have it here now.
So on that first page, obviously striking the spousal support, reducing the civil penalty to $100. Fees, you entered 500. I don't know if Your Honor was going to order reimbursement for the service fees. That was $95.
Yes.
Okay. Section 2, the hearing wasn't held on July 23. We're at August 13. I think the remainder of that page is probably fine. Section 8, again, removing spousal support, changing that civil penalty, the fees and costs, and the service fees. And then Your Honor didn't order jail time.
Correct.
So it does not apply. I guess in that other orders, if you want to strike that and put your language about the best efforts, no late payments on the Red Canoe credit card.
Okay, under 13. So all right, respondent shall make timely minimum payments on jointly held Red Canoe credit card. Okay.
And then I don't know if the clerk would require you to put in there that September 17th date, or if they're just putting that on the calendar right now.
I'll just put it here on the under court review under 12,
Okay.
September 17th, 2024 at 9 a.m. for pay or a peer review. Ms. Holder, any concerns with any of those edits?
No, Your Honor, I do not have any concerns.
All right, so I've made that. We'll strike the presentation docket that we previously set for the 23rd. That will not happen. And then we'll
Perfect.
see everybody on the 17th of September.
Very good. Thank you, Judge.
And Your Honor, how much was ordered in attorney's fees? 500?
500.
Thank you, Judge.
All right, that'll conclude the Mortensen matter for today.
You. All right, any other agreed continuances? Agreed continuances?
Your Honor, number 4, I believe, is an agreed continuance. Ms. Holder and I have been discussing. I never received the reply declaration until court prep this morning. I see it's on next week for a pay or appear docket. I would just ask that we set it over 1 week so I have the ability to review the reply.
Okay, let's go back. Which one are you asking?
Sorry, Judge, number 4, Mortensen and Mortensen.
Okay, 22-3-00388-08. We have Ms. Bliss, we have Ms. Holder. And so you're thinking, Ms. Bliss?
Just 1 week, Judge.
Ms. Holder?
1 week would be appropriate. I'm fine with that.
Okay. All right, so we'll go ahead and set number 4, Mortensen and Mortensen over 1 week, and that will be to September 17. And that will close that.
Thank you, Judge.
All right, going to Mortensen v. Mortensen, cause number 22-3-00388-08.
That matter's ready.
All right, I have Ms. Bliss. I have Ms. Holder. Anyone else appearing on this matter?
Yes, I'm here, Your Honor. Stephen Mortensen.
Thank you. All right, go ahead, counsel.
Yes, Your Honor. There are 2 issues here. First, this was a pay or appear docket to make sure that Mr. Mortensen was current in his monthly spousal support. I believe that issue was August and September of this year, just making sure that that was paid. And I do believe we provided evidence to the court and to Ms. Bliss that that indeed has been taken care of and he is current in his spousal support obligations.
And that's my understanding, Judge.
I'm sorry, Bliss.
I said that's my understanding as well. I did receive confirmation from my client and Ms. Holder that those payments have been received.
Okay. All right. Go ahead, Ms. Holder.
The second issue that we're here for today, Your Honor, is a motion to vacate those spousal support payments. I assume Your Honor has had the opportunity to read all the pleadings in this matter, so you're up to date on where we're at and the arguments of being made of, first of all, Ms. Mortensen no longer has a need for spousal support if she ever had a need, and that also Mr. Mortensen does not, nor has he ever had the ability to pay. This case has been going on for approximately 2 years. The temporary family law order was entered in September of 2022. Mr. Mortensen has had difficulty paying that spousal support for the pendency of this litigation, so much so that he's been held in contempt multiple times and has even been held in jail for his lack of payment. He'd had no attorney up until this point. The only attorney that was ever appointed to him was the one that was appointed prior to him being sent to jail for failure to pay. When my firm came on, we did a forensic analysis of his bank account and his financial situation to see where things were going sideways and why he was having difficulty paying every month. And it became abundantly clear that he never had an ability to pay due to his financial circumstances. And it also became clear that Ms. Mortensen does not have the need, and she especially does not have the need right now. She's provided no evidence or documentation to support anything she's asserted in her financial declarations. And she is now claiming that she can't work because she's sick when we haven't seen any kind of documentation of her alleged illness. She hasn't even put a name on it and said what is actually wrong with her, if there is anything wrong. In July of 2023, we became aware through her most recent declaration, her responsive declaration, that in July of 2023, Ms. Mortensen sold the home. And that home was bought with cash proceeds from the original sale of a family home. Ms. Mortensen then bought another home during the course of the marriage, but just prior to filing for divorce. That was taken with, again, community property with the proceeds from the house. That house was completely bought and paid for. It was then put into a hookup at a mobile home park in Woodland. That hookup cost was $1,200, and the utilities she was paying were approximately $490 a month, which put her financial need at $1,700 a month for where she was living. Now she's claiming that she sold the home in violation of a court order, and we've already filed for contempt for that matter. But she sold the home in July of 2023, took that money, hasn't disclosed where that money went, hasn't provided to the court or to my office any information, or to Mr. Mortensen about what happened to the house proceeds after she sold the home a year ago. So that house was valued at $126,000 when she bought it in 2022. So again, where'd that money go? She hasn't disclosed that. On top of that, she's claiming that she was forced to sell the home because she could no longer afford it because my client isn't paying his support payments. Well, now that she has moved out, she is now claiming in her new financial declaration, or her amended one, for her expenses, that she is paying $1,400 a month in rent, which that increased it by $200 a month. And she's paying $658 in utilities, which again is more than she was paying. So she's actually paying now $358 more a month than she was when she was living at the home that was paid for. On top of all that, she still hasn't provided any evidence that that is what she is actually paying or actually has a need for that. And while preparing for this case, this is not in the pleadings for the most recent motion, meaning the response and the reply declarations, but it is a part of the court record and it is very interesting. If you go back to the temporary family law order that was put in place in September of 2022, that was done September 27th. Based on the motion to get that temporary family law order, Ms. Mortensen claimed in her financial declaration that was filed in August 19th of 2022, and she signed that declaration on August 17th, 2022. She claimed in section 6 for her available assets that she had zero cash on hand. Mr. Mortensen, for that very hearing, before he hired an attorney, he also filed as a sealed financial submission the bank statements for the joint bank account with Ms. Mortensen's name on it. In that bank account on August 17th, the day she signed that financial declaration stating she had no cash on hand, she had over $19,000 in the bank account that she did not disclose. So what we have here is a situation that has gone on for 2 years where she has been getting support. She has sat on her hands. She has not moved this case forward. He has held my client in contempt multiple times, even sending him to jail when she has not established that there was a need. He has not established now that there is a further need, if ever there was one. My client has put forward his financials stating that I can't afford this. He took out loans to be able to pay for her support. That is not the point of support. He should not be having to take out loans to be able to pay her to live, because there has to be a need and there has to be an ability, and taking out loans indicates that there was no ability to pay. So we would ask the court to vacate the support payments because she clearly doesn't have a need. She has increased her living expenses without providing any documentation that she's done so. She has sold the family home and taken the proceeds. We don't know where those are. She hasn't disclosed close to, we assume, 6 figures. And also she's never provided the court or my client with any documentation stating what her actual financial situation is through bills, utilities. We don't know that she has paid off or paid down the debt that she assumed. One of the main sticking points for the litigations this far from Ms. Mortensen's perspective has been that she took on the lion's share of the debt. Well, she has yet to disclose if any of that debt has been paid down or paid off, which again would establish that there is still a need for support. So we ask that the court vacate the support payments. And we ask that she pay attorney's fees for having to put my client through all this for 2 years. And we also ask the court to order her to provide evidence and proof of what she did with the house proceeds from the house sale in July of 2023.
Ms. Bliss.
Thank you, Your Honor. And for the record, I do represent Brenda Mortensen. First, I guess I'm confused as to what counsel's request is today. The motion that was provided was a motion to modify spousal support. Her entire argument for purposes of today's hearing seems to be a CR 60 motion to vacate. Nevertheless, the motion before the court is whether or not spousal support remains appropriate. I believe it was Your Honor 2 years ago who entered the initial spousal support order. You found that there was a need. We're asking you to continue to find that there's a need. Before you is a marriage of 26 years. Mr. Mortensen was the sole financial provider throughout the entirety of the marriage, but for the last 3 years prior to separation. He earns upwards of, I believe it was $29 an hour, and he works substantial overtime at $43.50 an hour. He did just receive a raise in May. Looking at my client's income, she works part-time at Walmart. Again, this is a woman who spent the majority of her adult career raising 3 children, while Mr. Mortensen was the sole provider for the family. She works 33 hours a week and earns $17.24 an hour. As you are aware, and like you probably saw within the court record, we are constantly before the court on motions for contempt due to Mr. Mortensen's failure to pay the court-ordered support. We were before the court today to ensure that those payments were made. And what's ironic is on the eve of his motion is the only time he's ever been current and paid timely prior to a court hearing. He has been found in contempt at 3 times in the last 2 years, and that's over extensive pay or appear dockets that my client was forced to have him hauled into court to prove that he was paying. More often than not, he wasn't. What I find is ironic, he attempts to mislead this court into believing that he has paid $36,000 in spousal support over the course of the last 2 years. Again, if you look at the amount of times that we've been in court over failures to pay, the amount of times that he has had significant judgments entered against him for his failure to pay, and my client's declaration reporting he's paid $18,500, excuse me, as of the time of her declaration. It's very clear that Mr. Mortensen is continuing to thumb his nose to the court's orders and is now asking the court to either vacate or modify, again, it's unclear, to prevent him from constantly being hauled into court. But I asked the court to look at if there was a need, which Your Honor already found that there was, and that there is still a need. My client provides her budget to the court that shows she's, again, living on modest means and with modest tastes, so to speak. Looking at Mr. Mortensen's financial declaration, and if Your Honor looked in depth into the file, you'll find Judge Evans spent substantial time meticulously going through these financial declarations of Mr. Mortensen, because it's clear he's continuing to frivolously spend and live a life of luxury that my client simply is incapable of living due to his failure to continue to make these payments. If you look at his financial declaration, he indicates he spends $720 a month on eating out. He spends $510 a month on personal expenses. Again, these are luxuries that weren't that the parties didn't live during the marriage. My client provides for you that during the course of their marriage, they lived on one income and they lived modestly. Now he's living essentially the life of luxury, eating out for $720 a month, spending $500 on personal expenses, $500 in gas, and is living with 2 other adults. So his living expenses are shared. So my client wants the court to uphold the prior ruling if you are considering a vacate, which I don't think is properly before the court. But if you're considering modifying, I ask that you look at those and you see that, if anything, my client's financial position has worsened in the last 2 years, primarily due to Mr. Mortensen's failure to pay those support payments. She provides for the court that when the parties agreed, and Mr. Mortensen was involved in the purchase of the mobile home, that the parties agreed that Mr. Mortensen would pay $1,000 in lieu of maintenance to that space rent. That is the sole reason my client purchased that home. And then, naturally, as it does happen, Mr. Mortensen moves and then reneges on that agreement, says, nope, I'm not paying you anything, which is why we were forced to come to the court back in 2022. My client is of modest means. She again, spent most of her career as a housewife, taking care of the homestead. She was forced into employment prior to the separation and since separation to be able to sustain her own self and her own living, given Mr. Mortensen's failure to do so. We do believe that there continues to be a need. There's a lot of discussion as to where house sale proceeds went, where that she needs to furnish proof of X, Y, and Z. None of that's been requested of my client. If the court requests it, my client is more than willing to give it. My client does have some medical issues currently. She'd prefer not to broadcast that to open court. She's more than willing to provide it to Your Honor and to counsel. But again, that's never been requested of my client. My client has simply fought through this process, simply trying to get Mr. Mortensen to comply with the court's prior rulings. She's not just sat on her hands and not pressed this matter forward. And if you look at the record, we have pressed this matter forward numerous times, simply trying to get Mr. Mortensen to comply with the court's order. She has spent thousands of dollars in attorney's fees, simply trying to get him to force compliance, much of which hasn't been repaid, unless it was jail time threatened or contempt threatened. At this point, Your Honor, we're asking that you deny the motion. The request for attorney's fees is frankly laughable. Again, on the eve of this motion, we had another finding of contempt for Mr. Mortensen's failure to pay the court order, an outstanding attorney's fee judgment owed to my office due to that failure, and now essentially requesting either a vacate or a modification so that he doesn't continue to be held in contempt, I think is inappropriate. So frankly, we're asking the court to deny the motion before you today, and if anything, award my client attorney's fees for having to respond to this frivolous motion.
Ms. Holder?
Yes, Your Honor. In regards to the accusations that my client is thumbing his nose at a court order, he's not the one who did not fill out a financial declaration, not disclosing about $20,000 on cash on hand. He's not the one who violated a court order by selling a home a year ago. And I would say my client could be, forgiven for not requesting documents for a home sale when he just became aware of it within the last 3 weeks. We are currently in my office working on getting some discovery to Ms. Bliss's office, but we are also here now asking the court to order her as a part of this motion to disclose what happened to that money. We still don't know. As far as my client's wages and living a life of luxury, he makes $29 an hour, $43 for overtime. Overtime is not guaranteed. He pays $750 a month to rent out a room with 2 other people. Again, if you go back to the only financial records that I have for Ms. Mortensen that my client provided from the joint bank account, there's a lot of money going toward DoorDash and $600 at grants. My client's not the one who spent that money. That was Ms. Mortensen, and that was after she filed for divorce. So she's the one who's been living a life of luxury at the detriment of Mr. Mortensen because he's been stuck paying her spousal support. Also, as far as an agreement that he was going to pay her spousal support, my understanding, and from the record, it says the agreement was $1,000 a month, not $1,500 a month. It seems pretty clear based on what has been reported to the court and what has not been reported to the court that Ms. Mortensen is making allegations and she's making assertions as to her finances and her living situation without actually proving to the court that she still has a need. I believe the motion also says a motion to modify or vacate. My client would prefer vacating it, but he would be okay with a modification that is set to what her actual need is, which she still has not established now. Even if there was a need in the past, which Your Honor did sign off on that temporary family law order, he has not proved that there is a continuing need. We are now calling that into question. And we are asking that she provide documents to the court to establish that there is a continuing need. So she can say what she did with the money from the house, and she can provide bank statements or utilities or something establishing that what she put in her amended financial declaration is in fact true and there is a continued need. As far as my client living a life of luxury, spending money on food and getting himself food is not necessarily a life of luxury when he is a man living on his own, and that's what he's paying his money for, is to have food brought to him because he actually does have a diagnosed medical issue of diabetes, and he's been very clear with the court. Part of the other that is in his financial declaration is for his diabetes treatment and management. Again, this, even if my client was unable to pay previously and he did have an ability, now we're calling into question her need. We're still asserting that he does not have.
Let's wrap this up. I'm hearing the same argument.
Yes, Your Honor. We just ask that you vacate the spousal support or set it at a very much lower amount. If Ms. Mortensen can in fact prove that she still has a continuing need.
So here's what I'm going to do. Before the court does anything in regard to this, the court wants to see exactly what happened to the proceeds from the sale of the house. Supposedly there was about $168,322.89 in proceeds that, from what I can tell, are currently unaccounted for by the petitioner, and the court wants to know where are the funds. Meanwhile, the current maintenance remains, but the court will consider the request once it has more information from Ms. Bliss's client, in particular the house sale. And I'd like to know more about where she is financially on her bank accounts. So provide the accountings. I think it was October 8. Is that when the contempt matter is?
Yes, Judge.
Okay, so I'll set it to October 8 to get that accounting done. And then the court will take further look at Ms. Holder's client's request and go from there.
Does the court need any kind of written order in the interim, or we'll just handle it at the 8th?
Yeah, we'll handle it on the 8th.
Thank you, Your Honor.
All right.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Mortensen and Mortensen, cause number 22-3-00388-08. The matter's ready.
Good morning, Your Honor. Amanda Holder here on behalf of Mr. Mortensen.
Counsel, go ahead.
Yes, Your Honor. We're here today on two matters. The first one being the motion to modify or motion to vacate that we had previously filed. And then we're also here on the contempt motion. So first I will go over the contempt motion, as I think that one's pretty clear cut. Ms. Mortensen violated the temporary family law order by selling the family home. She never disclosed this until we brought about the motion to vacate the spousal support. She sold the home back in June of 2023. She's had plenty of opportunity to disclose it to the court and to Mr. Mortensen. She also never disclosed what she did with those proceeds until the court ordered her to do so. Her sale of the family home was not in the regular course of business. It wasn't a normal occurrence. Further, it was not done to pay for basic necessities. Nowhere in her responsive declaration does she lay out the necessities that she says that she needed to pay for to sell the home. In fact, she said that she sold it because she just couldn't afford to live there anymore. And according to her new financial declaration, her expenses went up after she sold the home. She said she couldn't afford it. There was a $1,200 lot fee. She then sold the home, and then she ends up living with her daughter, paying $1,400 a month. The house that she sold was bought for approximately $126,000. She sold it for $83,970. That's about a $40,000 loss in about a year's time. Not exactly sure how a home decreases in value by that amount of time. My client was unaware she sold the home, had no input if this was a reasonable price to sell it for. And then on top of that, she used the money. She's been sitting on it for approximately a year. She has about $37,000 in it in her bank account right now from the sale of the home. She, again, did not use it to pay for necessities. She might have used it for some basic living expenses, but she also did things like go to the spa, buy concert tickets, and pay $5,000 toward her son's student loans. Again, that's not a normal course of action, and it is also not a basic necessity. She is in willful and wanton violation of the court's order that was put into place. And she knew she sold the home, so it was willful. She did it out of her own will. And it was wanton because it was the largest asset that this couple had. And she sold it for a loss. So she wasted the money. And there's basically no money left from the family's largest asset. So we would ask for a finding of contempt. When it comes to the motion to modify or to vacate the spousal support, on her declaration as a part of the temporary family law order that originally started this case, and in her motion for spousal support, that the financial declaration she signed was filed on August 19th, 2022. She signed that document on August 17th, 2022. In page 3, section 6 of that financial declaration, assets or cash on hand, she left it completely blank when really she had $19,922.49 in the bank. She did not disclose that to the court. At best, she misled the court, and at worst, she lied to this court when she initiated these proceedings. Then in June of 2023, again, she sold the home, sold it for $83,970. That money has been in her bank account since that time. She said sold the home because she can no longer afford it. Then she moves in with her daughter. The living expenses go up. She does not have a need anymore for spousal support as she has all that money in the bank and she has had it and failed to disclose it. Furthermore, August 22nd, 2023, when she held Mr. Mortensen in contempt repeatedly because he failed to pay spousal support, when again, she didn't need it, she had the money. When she went for the contempt hearing and Mr. Mortensen was ordered by this court to do jail time for 2 days for failure to pay spousal support, on that date, she had $71,594 in her checking account when she held him in contempt, had him sent to jail. He's been paying support for over 2 years during temporary orders. She's taken the spousal support payments. She sold the home. She has wasted that money. She has blown through approximately $40,000 of that money, not including the $40,000 that she sold at a loss on the home. And she's sat on her hands, just letting this litigation go forward, not doing anything to finalize it, just wasting this money. She didn't hold him in contempt because she needed the money. She had tens of thousands of dollars in her bank account. She held him in contempt because she wanted to and because she could, and it was cruel, and she used this court to do it. Furthermore, she's now saying that she can't work because she's sick and she had to take family medical leave. Well, when she initiated family medical leave this last time in 2024, she was sitting on $50,000 in her bank account the day she started her leave. She didn't take family medical leave because she's actually sick. She's claiming that she has PTSD from this divorce. She's taking it because she knows she has money in the bank and she doesn't need to work. She's repeatedly held Mr. Mortensen in contempt for failing to pay his spousal support when really he's never had the ability to pay. He's taken on loans to make payments. And furthermore, she certainly does not have a need. She has not had a need for the last year because she has been sitting on a surplus of tens of thousands of dollars in the bank account, wasting the money of the house and the family's only asset. So what we're asking is for a finding of contempt. It's very clear that it was willful and wanton. She knew what she was doing and she did it anyway in violation of a court order. I'm also asking for some rather extraordinary findings, Your Honor. First of all, waste, because she sold the home. It was $126,000 when she bought it. It was $83,000 when she sold it. So she wasted $40,000 by not taking a reasonable price on the home. She doesn't explain why she sold the home at a $40,000 loss, and my client had no knowledge of her sale of the home. Then we're also asking for a finding of perjury because she lied to this court. She omitted information on her initial declaration. She has frequently laid herself out as a victim here when really she's a perpetrator. And she has held my client in contempt numerous times, even when she had tens of thousands of dollars in the bank and no longer needed his support. Again, she did it because she wanted to, and she did it because she could. Furthermore, we're asking that the remaining $37,000 be put in trust with my office until the finalization of these orders. It is very sad that of $126,000 asset, only $37,000 is left. And a lot of that has gone toward attorney's fees, both that Mr. Mortensen has paid Ms. Bliss's office, that Ms. Mortensen has paid for Ms. Bliss's services, and that Mr. Mortensen has paid for my services to dig him out of this mess. I would ask that the $37,000 be taken out, be removed from her bank account, put in trust immediately until the finalization of these orders. We're asking for $10,000 in attorney's fees for having to dig him out of this mess. I understand that back in 2023, he was held in contempt before all of this became an issue. But since doing a forensic accounting of her bank records and finding out that she's been sitting on tens of thousands of dollars while still holding me in contempt, it was necessary to spend an extraordinary amount of time to, again, fix this terrible wrong. And then we're also asking for a judgment that any spousal support that he paid from July of 2023, as that would have been the first support payment, asking for a judgment in that amount to be taken from her side upon final orders. And that we're also asking for the court to vacate spousal support. She's had spousal support for 2 years. That was plenty of time for this case to be litigated. And in that time, she has squandered their assets and there's pretty much nothing left. And we need to do something about it before there's nothing left. And everything that was left of the home is being spent in attorney's fees.
Ms. Bliss.
Thank you, Your Honor. For the record, I do represent Brenda Mortensen in this matter. Looking first at the contempt issue, as counsel indicated, that probably is the easiest issue. The court has no authority to find contempt. Counsel cites a motion for temporary family law order as her basis for my client violating an order. If you review the motion for temporary family law order, there's no mention of this home. There's no mention of paying for this home or maintaining the mortgage or any of that nature. The home was purchased prior to, after the date of separation. It is an argument of my client that is her separate property. I think that's a trial issue, not a motion issue. So looking for contempt, is there a willful and intentional violation to a court order? No, because that court order is silent as to this property. Even if the court were to find that my client did violate that order in some respect, it wasn't willful and intentional because it was in the normal course of business practice. My client provides to you that while she had that home, Mr. Mortensen failed to pay spousal support. The record is very clear that we've been before the court numerous times on motions for contempt due to his failure to pay spousal support. It is because of that my client then had to sell the home. She could not afford to maintain living there. Since then, as you saw in her bank records, she has had to start dipping into those funds again because Mr. Mortensen is not paying spousal support. The argument before you today is to stop spousal support and take away that nest egg that she's living off of. That is not just, and that is inappropriate. And again, think that's an issue for the trial court, not an issue for the motion. Before you is a motion for contempt. I don't believe that the court has the authority to order it. I am asking the court to deny the motion and the requests contained therein. Looking to the request to vacate spousal support, Your Honor heard lengthy argument from both Ms. Holder and I at the last hearing. You requested my client provide medical records and bank documentation. We have done that. If Your Honor had the opportunity to review the bank statements, it is clear that my client is using those funds to live off of. Again, but for Mr. Mortensen failing to provide and failing to abide by the court order for the ordered spousal support, my client wouldn't have to rely on those funds. Now, it's ironic that counsel is arguing that Mr. Mortensen has paid spousal support for the last 2 years. If you look at the filings before you, Mr. Mortensen has only paid spousal support when a motion for contempt was requested or right before this last hearing. So it's very clear he has not. And my client has provided an accounting in her responsive declaration. I believe he's paid 6 payments in the last 2 years. So to blatantly state he's paid 2 years of spousal support is a gross misrepresentation to this court. To be frank, when the court is looking for spousal maintenance and looking for need versus ability to pay, obviously we look at 2609090. The amount of money that a person has in their bank account is only one of many factors. Again, to make the representation to the court that my client doesn't need spousal support because she has this money, and then simultaneously is asking that this money be removed from her account is a gross injustice. So we are asking the court to deny both motions before you today. Again, most of these issues are issues for the trial court. Looking to the request for perjury, simply stating that my client omitted a line in a financial declaration is not perjury. Asking for waste. Again, if you look at the record, and the record is very clear, Mr. Mortensen has failed to pay spousal support, failed to do his duty under this court's order, failed to support my client. She had to use those funds to pay for her necessities. Sure, she has some luxuries, so to speak. She gets her eyelashes done or her hair done once a month, goes to a concert in the last 2 years. This is not a gross waste of the community assets, which again are questionable. Again, this house was purchased after the parties had separated. My client has maintained that house while she resided in there. Excuse me. Again, that's an issue for the trial court, not before the court today. To enter a judgment as to the amount of money my client received in spousal support versus what Mr. Mortensen has paid, again, is a trial issue. There's a lot of discovery that still needs to be completed, a lot of tracing of what funds went where, whether or not it was appropriate to order spousal support. The court ordered it 2 years ago and has not vacated that order before today. Obviously, that's what's before the court today. Numerous judicial officers have found him in contempt. Numerous judicial officers have ordered him to continue to pay spousal support, and he fails to do so. It is only after he is held in contempt the last time that he brings this matter before the court, asking to vacate not only the judgment or the order requiring him to pay spousal support, but is also asking to vacate and enter a judgment for all spousal support that he failed to pay throughout the lifetime of this case. I don't think that's appropriate. Again, I think a lot more information needs to be provided to the court. Testimony has to be provided to the court, and that's an issue for trial.
Ms. Holder?
Yes, Your Honor. He was held in contempt repeatedly because he never had an ability to pay, and that is part of the requisite for having spousal support. It's very clear that she no longer has a need. In fact, she has more money than he does. So if we're looking at the statute, need and ability to pay, neither one of them is there, and neither one of them has, at least for the ability has never been there. We contend that. And then as far as the need hasn't been there since at least the house was sold. If we pay attention to the temporary family law order that was put in place back in 2022, Section 6 says that it doesn't specify the family home. But Section 8 specifically says, do not move, do not transfer, do not sell any property. It doesn't say property that's included in this order. So to go back now and say that this motion for contempt has nothing to do and should not be heard by the court is ridiculous, because it might very well be a trial issue, but Ms. Mortensen was never going to get to trial before she ran out of all the money. And now that we have brought it before the court, I believe that the court absolutely has the authority and the purview based on the provision that says petitioner and respondent must not move, take, hide, damage, borrow against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic needs. So I think the court order is very clear on this. As far as the contention that we are asking for all the money to be taken from her from the sale of this home and put in trust, they might contend that the home is not subject to any litigation as it is separate property. The fact is, they sold the family home and she used that money to pay for this home that she is now claiming is separate property. Even if it was a trial issue, she shouldn't have done that because it would need to be decided at trial if it was separate property. Instead, she found a workaround in order to sell the house, live on the proceeds, hold my client in contempt repeatedly while she was sitting on tens of thousands of dollars. Again, I believe that what we are asking for is appropriate. She is in contempt of the order, and it is absolutely despicable behavior, quite frankly, and it needs to stop. And if we want to make it a trial issue, you can best believe that she'll find a way to spend this additional $30,000.
Objection, Your Honor, that's
all that's left
argumentative
before we
and
get to
beyond the
trial.
scope of today's hearing.
I'll sustain the objection.
So yes,
So-
Your Honor, we're asking for a finding of contempt.
All right, so I've reviewed the files and record, and in part one, this matter needs to get to trial. It's been pending for some time. It doesn't appear to be an overly complicated matter, so why it's still sitting out here almost to 2025 and not going to trial makes no sense. These issues can be dealt with at trial. As far as the idea of contempt, the court is not going to find contempt. The court has some questions in regard to the language. So to have it rise to the idea of willful and wanton disregard for the court order and an intentional action, the court does not find. And so will not be making any idea or rulings as to waste or perjury. Those two particular findings are reserved for trial. So I'm not going to rule on whether or not she caused waste or perjured herself. In regard to the issue on the support, again, this matter has been pending and it was shown and maintenance was ordered. And the court agrees essentially with what's being argued by wife's counsel in the sense that to say, well, I'm not going to pay you the support that I owe, but you do something so that you can take care of your living expenses. Now, agree, there are issues in regard to some of the things that she paid. There's no doubt about it. At the same time, the idea of coming forward, essentially no clean hands there, and to have it try to set it aside. Again, the court is not going to grant that. The issue as to whether the husband is given credit at some point at the time of trial, that's a trial issue, and I'll leave it for that. So it's a mixture of one, not finding contempt, two, not going to terminate the maintenance at this time, as far as whether the husband can, or excuse me, the wife can claim separate property on what she sold will be left for trial. The waste and perjury left for trial. In regard to, again, the maintenance, the court is not terminating that. However, will be reserving as to whether or not the husband can get credit for what he's paid. And then attorney's fees are reserved as well.
Your Honor, while maintenance has not been vacated, is there any way to modify it based on the fact that she does have that money still in her bank account?
No. And so it's understood. It's from everything I've seen, she sold her home to survive because he's not paying the maintenance that he was ordered to pay. So no. Presentation October 22nd.
That works for me.
Okay.
Thank you, Your Honor.
Thank you, Judge.
Instead of having the presentation of order hearing, both sides agreed to stipulate that the order was correct. It's fairly common in this courtroom for the judge to encourage the parties to stipulate to the order if they are in agreement. That way no one has to come back to court. Odyssey shows that the couple has a mandatory settlement conference scheduled for November 27th. I hope that they can work out all their property issues without the need for a trial. There aren't a lot of assets to fight over, but it would still be best if they can sort this out for themselves. If they leave Judge Hahn to decide, they might be really unhappy. I wish them all the best. There shouldn't be any more updates in this case now that Cowlitz has done away with Zoom hearings, but if that ever changes, you guys will be the first to know. Thanks so much for watching.